Thank you so much for joining us at the fourth annual Intellectual Property Law Conference here at Cleveland State University. And I wanted to start by thanking all of the people who make this possible, including our co-chairs, John Sapola, Carl Mersch, and Ari Sherwin, who have for countless years put way too many hours into helping us prepare this, as well as Jill Natran, Rick Zhang, and the incredible staff that helps make all of this possible, and our IPTA students who are in our intellectual property student group, Dylan Ramsey, Alan Scheis, Brock Jones, and Casey Fisher. So we have an amazing conference planned for you guys today. We're going to start out with a fireside chat featuring the Commissioner of Patents, Vaishali Udupa. And she's going to share her experiences at the Patent Office and provide insights into things like how patent law is evolving and some of the challenges and opportunities of new technology. It should also be a really fun conversation because it's going to be one with Carl Mersch, her longtime friend and former colleague as well. Then we're going to be turning our attention to medical technologies and healthcare in the intellectual property space. Healthcare has an important spot in Cleveland's heart, including because we have Cleveland Clinic, UH, and other major research institutions here that contribute a lot to the healthcare innovation ecosystem. Our panelists are going to include a group of inventors, as well as someone from the licensing department at Cleveland Clinic and a venture capitalist who invests in the medical tech space. Later, we're going to address the ethical and legal considerations of artificial intelligence with a special focus on synthetic media and deepfakes. And these have created quite an issue for politics and also for our own personal privacy with the rise of AI. So we're going to talk about the legal implications, and you'll be able to get ethics, CLE credit there, including through our discussion of how that might affect you in the legal profession and in protecting client confidentiality. We are also going to end with an in-depth review of the changes that have happened in intellectual property law, both substantive changes like proposed regulations on terminal disclaimers and other issues in intellectual property law, but also changes to practice, including how women and underrepresented groups are now more prevalent in intellectual property law than they ever have been. So it's a comprehensive program that's designed to create a very fun day for you. One more thing before we dive in is I wanted to celebrate how far intellectual property has come at Cleveland State University since we started this program. We started the Intellectual Property Plus conference in 2021. And in that time, there have been huge changes to the program here. So we have had amazing speakers that have come, including Judge Kathleen O'Malley, Laura Quitella, and the people who represented the parties in the Warhol case at the Supreme Court. But we've also had changes at the school, including huge risings in the ranks of the US News specialty rankings. I just checked the numbers, and Cleveland State has risen over 50 points in the US News specialty rankings for intellectual property in the last 5 years. We are now ranked number 82, cracking the top 100 for the first time, and at the highest level in the school's history. So I think that's definitely something to celebrate. We also have a thriving student group, the Intellectual Property Technology Association. So for those students who are in the audience, I highly recommend you sign up and attend some of the interesting study sessions and other interesting panels that they put on. We've added a number of new courses in that time. We relaunched the Copyright, Patent, and Trademark, or IP survey class. We've added a class called Innovation Law that I run that's on the policy issues in innovation and new technologies. We also in 2023 launched a new course to a lot of fanfare on the practice at the U.S. International Trade Commission taught by attorneys at Jones Day, including Ryan McCrum, David Moriana, John Evans, and Susan Gerber. And they taught practical drafting exercises to students. That course is going to be offered every other year. And then we also have a brand new professor in the intellectual property space, Mahtab Khan, is joining this year. She's teaching intellectual property survey and a new course called AI Law, where she's going to focus on the legal implications of artificial intelligence. We also have students that are starting to graduate with our new IP certificate. This is for students that earn a 3.0 or higher in 12 credit hours of IP. So if you see this certificate on the application of any students that you see, know that those are some of our top students who have dedicated a large portion of their study to intellectual property and performed very well in those classes. I think it's some of the best training that these students are going to be getting in Northeast Ohio. So what can we do to help support and continue all this progress that we've been making? Well, we definitely need your donations and help. This program is funded by sponsorships. We make it free through the help of our generous sponsors, including John Sapola, Hill Coast Dream Bank, and Tiroli and Renner Auto. And if it wasn't for their donations, this kind of programming wouldn't be possible. So I encourage you, if you can make a donation to our school, which is operating on a shoestring budget, you can make out a check with a memo line to the IP program and hand it to Jill or myself, and make it out to the school as a whole. But we also are looking for a donor for an entrepreneurship center. And for that, we need a large endowment donor. So if you have any leads or introductions that you can make for a donation that would help to support an entrepreneurship center here, please let me know. We would like to offer a clinic for our students to allow them to practice intellectual property law under supervision of a clinic director here at CSU. So we do need donations to help support that. So without further ado, let's jump into our program. And here is Carl Marish, a longtime supporter and co-chair of the IP conference, a good friend, and to introduce the Commissioner of Patents. Thank you, Carl, for all the work you do. And thank you, Vaishali, for coming.
Thanks, Krista. Ooh, it's a lot loud. The one thing Krista left out about all the stuff she said, the good things that are happening at Cleveland State Law School IP program, is Krista Laser is the driver of it. And it's no surprise that everything's turning to seashells and balloons since she got here. So thank you. So as Krista said, my name's Carl Marish. I'm a senior vice president of Hill Coast Dream Bank. I run a division that helps people generate strategic intellectual property and then monetize their intellectual property. I'm also a former patent attorney, and early in my career, I had the opportunity to work with my friend Vaishali Yuduppa from the DC office of Jones Day, who's now Commissioner of Patents. Welcome to Cleveland.
Thank you so much.
So can we go one slide, please, Rick? So what I wanted to do, those of you in person are likely from Cleveland, so none of this is going to be news to you, but we have like 200 people on Zoom from all over the world. So I thought we would spend a little bit of time introducing everyone to the few things that Cleveland contributed to the practice of law and patent law, frankly, in the country. So I picked up Vaishali yesterday at the airport, and the first place we went was the corner of 105th and Euclid Avenue, which is right outside the Cleveland Clinic. This is the location of the first electric stoplight installation in the United States. So the electric stoplight system was invented by a Clevelander. You can see the patent number up there. And the claims are fascinating. The system has stoplights at four corners of the intersection connected by wires both underground and above ground. And there's actually an operator that sat in the booth down here and operated the signal and directed traffic. And I thought for sure that when we went out there, there would be some sort of memorial to this, and there wasn't. So it was just the two of us standing at the corner of 105th and Euclid Avenue. I think we were talking about the finer points of ITC practice, and people around were probably like, what are those two people doing? But anyway, pretty interesting. This was in 1914, August 5th, 1914, the first electric stoplight in Cleveland, Ohio. Oh, can I advance? Okay. All right. The next place we went, and this is the you know it if you see it location, and this is the Heights Theater in Coventry. So if you guys remember when the Supreme Court case Jacobellis versus Ohio, where they're trying to interpret what obscenity is, and Justice Potter Stewart, his famous concurrence is, I can't define what obscenity is, but I know it when I see it. So that actually, the facts that gave rise to that case and that holding happened in Cleveland Heights, Ohio. So I traipsed Vaishali out to the Heights Theater, and she reluctantly allowed me to take a picture. But in 1963, there was a French film called The Lovers that was being filmed. Ohio had passed a statute prohibiting the disposition or showing of obscene materials, and the Cuyahoga County prosecutor and the Cleveland Heights police chief went to the showing of this movie. When the scene, it's a female orgasm, is the offensive, is the allegedly obscene material, which today in this day and age seems entirely ridiculous, but this was 1963. They stopped the production, arrested the projectionist, who also happened to be the manager, and he was charged with violating the statute. It goes all the way up to the Supreme Court of the United States, who rules that it's protected by the First Amendment. And that's where you get Justice Potter's famous quote, which as we talked about yesterday, I think that applies to the Alice doctrine. It's like, we don't really know what it is, but we know it when we see it. And that's how we're applying it these days. We can talk about that later. So that's stop number one, or stop number two. Stop number three was right here at the corner of 13th and Euclid, where the Terry stop, another Cleveland contribution to our way of life, occurred. And in that, and here's a map that was taken from one of the briefs, but in the Terry stop, Officer McFadden with the Cleveland Police Department was just walking along Huron Road, and there was a jewelry store at the point right there, which is obviously now, it's actually now the hotel where you stayed. And there were three guys walking suspiciously around this jewelry store, and it turns out they were casing the jewelry store to potentially rob it. Officer McFadden stops them, searches them, finds a gun and some other things, puts them under arrest, goes all the way up to the US Supreme Court. And the issue is, did he have probable cause? No, he didn't have probable cause. So he should have not been able to stop them. The Supreme Court introduced this stop and frisk notion, where if you have reasonable articulable suspicion that criminal activity is afoot, you can stop someone and detain them briefly. And we see this in everyday life with, police officers able to pat you down to see if you have a weapon, make you look in your glove box if they pull you over, et cetera, et cetera. But all that happened right here at 13th and Euclid. The funny part of this is I knew there was a marker. And so I took Vaishali to this intersection. We parked the car illegally, maybe. And Vaishali's like, you can't park there. And I'm like, it'll be fine. There's nobody's going to do anything. We literally walked around this intersection at my direction for 10 minutes looking for this thing every which way. Then we found something on the internet that said it was at 2nd and Lakeside. So we drove over to 2nd and Lakeside, and there's a monument there, but it's to George Forbes and all the work that he did. So I ended up dropping Vaishali back at the hotel and walked back to my car, which was again parked illegally. And this monument was right next to my car. And we got out of the car. I mean, we were, ever since we got up, picked her up from the airport, we've been yammering about whatever. We completely missed it. So that was our welcome to Cleveland. And then 2 more stops we made. Oh, I'm sorry, Rick, I'll advance. We, of course, stopped by the mothership, Jones Day, nights and weekends. They don't put that on the sign, but that's where Vaishali and I work together. And we stopped by there. And then no visit to Cleveland is for, an out-of-town guest is complete without a stop at the Christmas Story House to see our major award. So that was Vaishali's introduction to Cleveland.
It was a wonderful introduction. I've been to Cleveland many times, but I've never gotten that, such a wonderful tour. I usually just had to go to Jones Day and then start working.
So with that introduction, let's get into you being Commissioner of Patents. So and I think Krista alluded to this, the double-edged sword of Carl Mayers doing a fireside chat is we're likely to spend more time on things that don't relate to patents and relate to funny stuff or things that I find entertaining. So tell us about growing up in Wise, Virginia.
So many people might not know, or sooner or later when they get to know me, I do talk about how I grew up in Wise, Virginia, and you have to say it that way. So it's a very small town in Appalachia. It is in the mountains. And I moved there when I was 13 years old. I think it was a beautiful place to spend those formative years. One, because there wasn't a lot to do. So a lot of people played sports and tennis was a big part of my life. So I did that. But then also, I think it provided a lot of confidence, not to say that there aren't like smart people there, but it was like I had the ability to just do whatever I wanted in school. They gave me a lot of leeway. So especially with math and science and things like that, they just let me take sort of the courses I wanted to take and even go to the local college to take classes. So I think it built a lot of confidence in me with science and math. And and it's a beautiful, beautiful place. I don't know if any of you will ever make it there, but if you do, it's just in the mountains. It's absolutely gorgeous.
Okay, so tennis. And I know this because so Vaishali and I worked together at Jones Day, and we worked on I think it's the largest patent infringement lawsuit in US history. It was 57 patents. There's a lot of our former colleagues out here that will probably raise their hand and correct us if that's wrong. But it was Kodak against Sony. And to this day, when I advise companies on monetizing their intellectual property, and they're like, okay, we're just going to file suit. And I'm like, okay, it's a little bit of an art and a science here. Don't do it the way Kodak and Sony did. The way Kodak and Sony did is Kodak sued on 3 patents. And then a couple weeks later, Sony countersued on 4 patents. Not to be outdone, we represented Kodak. We then sued on 5 patents. And then Sony came back and sued us on 6 patents. And we went like that until it got to 57 patents, when the general counsels got together and said, okay, let's uncle this and just try this case as it was. But anyway, so in the course of us working together on this lawsuit, we spent a lot of time traveling, doing various things. And so I know all these fine details about Vaishali. You mentioned tennis. You didn't just play high school tennis. Like, what was your thing in high school tennis? Your team and you.
Okay. So I was number 1 seed. We won the state championship. In Virginia, I think the record still stands. We have the most consecutive wins and most consecutive state championships starting from when I was there, 9 years in a row. And
Number 1 singles. She was number 1 singles.
And tennis still is my life, and that's also how I had my first date with my husband. So.
Oh, did you really?
Yeah.
You guys played tennis?
On that trip, we played tennis, and I lost, and I had to take him out.
Oh my gosh. So I was actually there in the DC office where Vaishali was based the day of her first date with her husband. And so got in the next morning, went to her office, and I was like, how was it? And you said, or how was he? That's what I said. How was he? And you said,
see, he brings it up every single time whenever I post on Facebook. Oh, it's our 15th anniversary. This next year will be our 20th anniversary. And I'll say something nice. He's like, well, I remember when you told me he was dreamy. And so when I was coming, when I was leaving and I was telling, oh, I'm coming to this conference and I'm going to speak. And, oh, do you know that guy that always says the dreamy comment? I'm going to be seeing him. He's like, oh, that guy. Okay.
Don't friend me on social media if you have embarrassing things you don't want the world to know. That's the lesson there. So from Wise, Virginia, you go to UVA. I've never asked you this. I don't know the answer, but you majored in civil engineering, which was surprising. What was the initial thought on engineering in general? I mean, you said you are big into math and science, but why civil of all the disciplines?
So I guess also I love math. I actually went to UVA and I was in the College of Arts and Sciences, and I was going to pursue a math degree. But another thing I really was interested in, I thought about maybe being an architect. I loved design. I loved art. And so when I said, this is not right. I feel like I want more. I sort of enjoyed the engineering aspects and science. So I started taking classes my first year, my second semester in engineering school, and one of them was all like a class that talked about all the different disciplines. And I remember there was this when they talked about civil engineering and sort of the I don't know exactly what that principle was, but when you stack a bunch of blocks and you move them over and over, they're able to balance themselves and sort of like that, how they create arches and things. And I was just so intrigued by it. And I said, there's something that's calling me to this. Also, it's the other side of sort of architecture. So that's when I started pursuing that. It'll be funny. Even on the side, I built my house. I've also built other houses and love designing houses. Trying to find my neighbors who will sell their lot and then do that because it's really a calming place for me. So I still enjoy that.
Yeah, that's funny. You interviewed, I think I read this somewhere, maybe you told me, but I think I read it somewhere that you had an on-campus interview with the USPTO, and you got rejected.
I didn't get rejected.
Oh, come on. It makes for a better story.
I was not a US citizen.
Oh,
So it's ineligible. And he told me to come back when I got my citizenship. And I remember that person's name. And I kept in touch with him. And he said, so I guess it could be. I mean, I won't take it as a rejection. I take it as they left the door open. And then 26 years later, I finally walked through the door.
That's pretty funny. So you got an eligibility rejection your first try at the office. And so is the person that you stayed in touch with still at the office?
No, he's not. Yeah. So we kept in touch, and then I worked as an engineer. I went to law school.
Why American?
Why American? Because they accepted me.
I have a similar. That's how I got into law school.
There's other schools that I was thinking about, but and I wanted to be in DC. I was working as an engineer in DC, and so I had also deferred my acceptance for 1 year. And it was a great school. I really enjoyed my time at American.
So American at that time had, as I recall, had all kinds of adjuncts from the DC patent bar that would teach night classes there. Did you go full time, by the way, or are you at night?
Yeah, I was full time.
Yeah. So I assume that you had that kind of set you up for your first job.
Well, it's sort of interesting. I'm always thinking about what I should be doing. So when I worked as an engineer, I was a project manager and I was building a semiconductor plant. And we were also doing some work at University of Maryland, things like that. And so I was on construction sites. And then I thought, well, maybe I do construction law. So my summer associate position was actually at a construction law firm. But then I took the patent class and absolutely loved it, did the patent moot court. And I just realized it was that perfect mix of law and science. And so from that point on, started trying to get a patent job.
Gotcha. Interesting. So then your first job is not Jones Day. It was
Penny and Edmonds.
Which ironically eventually became Jones Day, but that's a whole different story. So you started your career as a patent prosecutor.
It was primarily patent prosecution, and many people don't know that. They think I'm just a litigator. So I did patent prosecution there. There was a lot of opinion work that I did. And then there was a little bit of litigation work, but it was in the New York office. So I asked to be in the New York office for 6 months to get more exposure to litigation. I realized I didn't think I could live in New York, came back, but I also realized that Penny and Edmonds wasn't doing so well. And I probably had to go to another firm. So at that point, I went to Jones Day, and a year later, Penny closed its doors and came to Jones Day.
Yeah, that was interesting. And okay, so did we work on any other cases together or just Kodak Sony? My recollection is it was just Kodak Sony.
I believe it was.
Yeah, but it was so encompassing. And you know what, you talked about project management. They put me on the Kodak Sony case. You probably don't know this. Kodak wanted to bring project management to this massive litigation. So, and all the Jones Day folks that know us are going to kick out of this, I think. it ultimately it's a story. It's self-deprecating and it's 100% accurate. They were looking for an attorney who had been an engineer and a project manager, or theoretically had project management experience before going to law school, and they found me. And so they put me on this 57 patent lawsuit to be the project manager. And anyone knows I am as disorganized as, like, you can't make it up. I'm so disorganized. So the irony of like this big break I got in my career is because they thought I was a project manager, which is something that, that is a skill that engineers generally bring to the practice. So you move to Jones Day. How long were you at Jones Day?
I was there for 8 years.
Okay. And then you went in-house to Hewlett Packard at that time, or Hewlett Packard Enterprise?
It was Hewlett Packard at the time. It was funny because back then everyone said the maternity leave that you would get in-house was not very good. So they all said, finish your maternity leave at law firms and then go in-house. And so I had my 2 beautiful boys at Jones Day. They had a really great maternity leave policy. And then I went to, and as I was on maternity leave with my second is when I got the job at HP.
Yeah, there's this notion, this is a message to the law students. There's this notion that when you leave private practice and go into an in-house role, that you work less. And that is a complete misnomer.
It's different.
It's different. It's different. You don't have to write down every 0.25. But you still, there's a lot of work to be done.
No, at one point at HP, they started making us record our time.
Really?
Yeah, it was partially, I think they were doing the split. So they wanted to know what work was happening and what type of work, so they could know where to put people.
Gotcha. That makes sense. Can we talk about your boys for a little bit?
Yeah, sure.
Okay. So junior and 8th grader.
Yes.
Junior is an athlete just like his mom.
Different type of athlete. But no, he plays tennis too.
But he's made varsity basketball at Georgetown Prep as a freshman.
Georgetown Day School.
Whatever.
They're completely different schools. One has people like Ruth Bader Ginsburg who sent their children, and Ketanji Brown, and the other one is Georgetown Prep. People might know from Gorsuch and Kavanaugh. So they're very.
Oh, interesting. Okay, I accept that. I withdraw my whatever. Okay, and your 8th grader, athlete as well?
Yes.
Tennis, basketball?
Baseball and basketball.
Baseball. So do you play tennis again? Do you guys have like family tennis matches?
When we travel, we do play. And when they were younger, they didn't like playing with me. I remember I would say, I put up these tennis balls to create a little pyramid, and I would tell them that you have to knock it over and then we'll get ice cream. And they didn't knock it over, and I didn't give them ice cream.
It's cold.
And they were just like, what are we talking? How could you do that? So I don't know. Maybe they thought it was a little too harsh.
That is so funny. And you're you theoretically could play, or do you play like a doubles tennis match as a family?
Yeah, we do, because even though my other son plays baseball, we all play. I mean, it's fun when we travel. And for a while, my husband and I were actually doing USTA together and working on our communication skills through the process. But it was, tennis still continues to be. I just played this last weekend.
That's funny. My daughter Ava played tennis, who anyone who's a Facebook friend of mine knows that to be true. And I'm terrible at tennis, but all I did was buy on Amazon this humongous thing of balls, and I would just stand at the net and throw balls to her, and then I'd go pick them up when we were done, and then I would do it again. That was the extent of my tennis. Okay, let's talk about the meat and potatoes. You are the commissioner of patents, and what's unique about that, to me, and I think this was sort of a thing that came up in the patent bar when you were named, is you are the first non-examiner to be named commissioner of patents. How have you found that to be? As I don't know that you're an outsider. I mean, you have a reg number, you know what you're doing, but like, what's it been like joining, having no background coming up through the office like most of the other commissioners have had, or all the other commissioners have had?
I think it just brings a different perspective. And so the previous commissioners for patent were they brought a wealth of knowledge. They grew up at the USPTO, and so they understood every nuance of it. When I came in, it was definitely a learning curve, but I think one of the biggest things that I hope that I've provided, and also I had to come in and build trust because people didn't know who I was. And so that took time, right? And let them know that, I've got their back. I'm trying to do things to help the agency better. But it was a lot of what I'm doing is looking and asking, why are we doing this? And having them explain to me. And well, sometimes you get the answer, well, we've always done that. And I'll say, but why are we doing it now? And does it make sense? And so here's an example. Recently, there was a Federal Register notice on AFCP 2.0. We've been doing it, I believe, for 13 years. And it's, after final.
Yes, that's.
Yeah.
Okay.
So they have traditional
AFC after final continuation.
practice. Or I don't know if that's right. I think it's after final continuation practice. There's too many acronyms at the USPTO. And that's another thing I'm still learning. And they want to create acronyms for every new initiative they're doing. So you have traditional after final practice. And then what they were realizing at that time, they said that there was a lot of things that were close to allowance. If it was just a little bit more time, maybe an amendment that could be done, we could get it over the finish line. And so they created this program, and it was a pilot. And it was happening, but what they're realizing, they said, okay, you could do a small amendment. They weren't always small amendments. It was requiring more search. And the examiners were given 3 hours to conduct this extra work, but it was so much more that was involved. We were also noticing that the allowance rate for traditional was about 46% after final practice, but with AFCP, it was 23%. It was not meeting the purpose that it needed to meet. And it was, for examiners, they didn't value the program either. It wasn't making their lives easier. So asking, why are we doing this? And also, we also went out and it costs us money to run this program. It was a fee program. So we thought about having a fee for this. And what we're seeing from our stakeholders is they just didn't find it valuable enough that they were willing to pay a fee. So we're losing money. Examiners didn't really like it. And it wasn't reaching like the intent of what it was supposed to do. So I said, let's scrap it. And we did. And so I think what people need to understand, some people are like, why are we getting rid of AFCP 2.0? And so we're doing this process of trying to educate people. But that's what coming in and asking these questions. Because sometimes when you're in it, maybe you developed it, you're so tied to it that it's hard to let go. And so coming from an outside, trying to do some of these changes.
Yeah. Makes sense. And I mean, this is editorial, but I mean, obviously I love you, but I think this is exactly what the office needs at this time. Like, I think it's such an interesting time for patents, and the pendulum on the strength of a US patent has been swinging back and forth. And excuse me, having somebody with an outside perspective, especially in an age where you guys are under so much pressure, having an outside perspective is genius. And
my term is 5 years, and it's not to say that the next one should be someone who's homegrown or outside. I just think that each one has, I hope I'll have some benefit after I leave on the agency. I think each one provides so much value.
Yeah. What do you, this isn't on the outline that we talked about, but 5 years, what do you think after that? Federal Circuit?
I think, I don't know yet.
Can I start that rumor?
No.
Would you still come back to Cleveland if you got named to the Federal Circuit? Would you come back here and speak to us?
If you ask Carl.
That would be awesome.
No, so if someone had told me this is what I was going to do 5 years ago, I wouldn't have believed it.
Yeah.
And as this opportunity presented itself to me, it was something, I'm extremely blessed for this opportunity. And so it's hard to say, do I know what I'm going to be doing in 5 years from now? So we'll see.
Yeah, that's interesting because I think you were getting more and more responsibility, HP, outside of IP, which is not the easiest thing to do when you're an in-house lawyer, is to get more responsibility. And it felt like you were on the fast track to be general counsel somewhere. So yeah, I would agree. This was a departure, but what a great opportunity. What's the biggest, if there, was there any big surprise when you took this role on? Did you think it was going to be a certain way and you found it to be a different way? Or do you have any big surprises?
Well, I think initially coming into the USPTO, or when you think about government, maybe there's this, I don't think everyone has this misconception, but there is this misconception. It's inefficient. People, aren't, they don't work as hard, things like that. The people at the USPTO are such hard workers. They are so committed to the agency and especially the people I interact with. I see the examiners but also there's these executives that I'm working with, and just how smart they are, how much they know, how much, I think like they could be successful anywhere. So that's one thing. The other thing is the USPTO, we are fee funded and we don't take taxpayer money. And that's sort of the financials of the USPTO is something I was truly unaware of. And so whatever fees that we get, we use that to run our programs. And we also use it to, create our reserves so that even if the government's going to shut down, we are able to operate for a while. And they operate like a business. And so I think that's another great thing about the USPTO is the way that they operate, the way that they think about their fees and making sure it covers the cost. And just the programs that we're able to do as a result, or our ability one of the biggest things we're trying to do is get more examiners right now. But we were able to also get the special rate table so that they get paid higher. So these are some of the great things about the agency.
So obviously we're at a law school. Can you talk a little bit about is it the career path coming out of law school and becoming an examiner, especially in light of the fact that you guys are hiring? Do you think law students should consider that more? What do you think of that as a career path?
I was just talking to someone right before we started today, and I was
the chemistry, the guy with the mask on that majored in chemistry.
Oh no.
Go, because I told him you should talk.
Okay.
Talk to you.
And it was I think it's a fabulous place to come.
Yeah.
One, the government, I mean, as an examiner, I think with a law degree, you provide, you have a good perspective. And if you've taken a patent law class, you're probably one step ahead of other people who are coming right out of undergrad. They're trying to understand what 101, 102, or things like that. Also, people don't understand the benefits of the USPTO is with regard to the special rate table. And they have a lot of promotions come very quickly at the USPTO. So then you can get paid in the high 180s, and with your production bonuses and your docket management bonuses, making a good amount of salary, but you can work anywhere you want to.
Oh, you can work remotely?
You can work remotely. So you can be working in Wise, Virginia, making that type of money. And so it is, or wherever you want to work, and it's a wonderful job with great. I mean, the government benefits are amazing.
Yeah. So I asked you for the surprise, what you were surprised by at the Patent Office. Honestly, one of the things that I was surprised by, and it just comes from talking to you since you've been in this role, is the amount of attention that you all pay to data. Like when you were giving the example of the after final practice, you're spouting these statistics about X, Y, and Z. It never occurred to me that the Patent Office was so focused on data, which I think is refreshing because it's always, how are we providing the service to the applicants?
Oh yeah, there is our one of the people that I work with a lot, Greg Mills, he's our data guy. we look at just everything. How can we increase production? How can we, what do we need? How many people we need to hire? I mean, there's all those projections that happen, but also from if we, like one of the things we felt that after the pandemic, people were burnt out and we needed to see what we could do with regards to production and is there ways that we could incentivize and the amount of data analytics we did and we changed how you had to have a very high level of like rating to get a production bonus. And so it was at the highest level. And I said, well, there's still the next level down where they're making 103% and they're why don't we lower the standard a little? Because what we were noticing is that people weren't trying to do more. They were actually trying to do less because I think they felt it was too hard to reach those higher production numbers. So I said, let's lower the standard and make it where we could at every increase in, if you're at 103, then you could get it also at 104, not this huge jump. And we implemented this new gain sharing model, and it was the first time since 2019 we saw a production increase and the largest increase since 2015. So, I mean, it's things like that. We looked at the data, we try to make informed decisions.
Yeah, interesting. Okay, one of the things, and I think it's related to what you just said, but one of the things that I know you've implemented is pendency reduction plan. Can you talk about that? What your goals are? How's it work? Et cetera, et cetera.
So sort of to take a step back, around the 2019 timeframe, there were changes that were made, really good changes. We gave, and I wasn't there at the time, but they gave examiners more time because they wanted to work on quality. And in that plan, they also said that they needed to hire a lot more people, 300 or so extra people to make up for this time. If you look from the 3 years going forward, the delta of new examiners was only 32. So we did not get the examiners we need. And part of it was the pandemic hit, things like that. We didn't know, they didn't know where the filings were going to go. But surprisingly, filings did not dip as everyone expected.
Everyone's sitting around inventing. There's nothing else to do.
Yeah. So now we're at a crisis. Our inventory is nearing 800,000. And also when you hire an examiner, it takes 2 years for them to be really providing a benefit to help with our inventory reduction. And so we just said we have to be aggressive. But there's a lot of things. It's not one lever. If I just hire a bunch of examiners, that's not going to answer the problem about reducing our inventory. So we tried to look at what are the key movers to help move cases. And so we have things with hiring. We have a huge hiring goal of 1,600 examiners for the next year. We have, and for the out years too, we have very high numbers because we need to bring people in because our filings are going up. But last year it went up 2%, or this past year. And then we are looking at how we can reduce retention. And even the last 2 years, we've done a great job. We were at 38% with the first year examiners, attrition. And the first year I was there, it went down to 34%. I think our number is going to be about 32% this year. So we're trying to, get people engaged. They feel like valued and things like that. Then we know we need to make sure the way that applications get to examiners, that routing process it's not completely broken, but it could be refined. So we're working a lot to change our routing process and the amount of time that people make sure that they get the right amount of time in our workflow, the tools that we're providing, and also looking at different ways that we can incentivize. So we just finished another, we call it 1 for 1. And so we said, look, if every examiner did one extra case per the last 2 quarters, we would, there would be, and if we hit a target, we would give a bonus. And it was for everyone. because the patent office is like, it's not just the examiners, there's like so many people play a role in making sure that we get things done. And we ask people to think outside of the box. How can we help with this initiative? And people were came up with creative ways to process the patents faster, reducing times even by 2 days. That again increases production. So very excited. We hit our number, exceeded our number. Even with, we had, I don't know if you know, a few months ago with CrowdStrike, where, all the airplanes went down, the blue screen of death. Well, the blue screen of death came to the USPTO. We have 14,000 employees, approximately 8,000 of them were not able to work, and it lasted almost a week. And we were getting people on, but it took almost a whole week to get everyone back on. And even with this huge production loss, we exceeded our goal.
Oh, wow. Amazing. So tell me again, the hiring goals for new examiners?
1,600.
1,600 this year?
Last year, we set a target of 800. We increased it. We got in about 850. So we didn't set a cap. And then this year we're looking at 1,600. We also know that when you hire a bunch of examiners, we need to make sure that we can absorb them. So we're doing a lot in that regard with regards to increased manager hiring. And then what are we going to do in our training? Another thing is we went during COVID to completely virtual. It's called the Patent Training Academy. And so I've asked the team, let's consider a hybrid model so that we get them in for 1 to 2 weeks so that they can build connections so that, so often when you're a new examiner and any type of new employee, you need to have those people that you can go run to, ask questions, or even your colleagues, because you're scared to ask your manager, and so you work through it. And so we're trying to build those connections.
Yeah, interesting. Your team's pretty impressive too. I sent Vaishali an outline of the things I wanted to talk about. And what I got back in response was a meeting notice with Vaishali and 6 other people at the USPTO. And I was like, oh my God, they're all going to be like, what is this guy thinking that you're going to talk about? And we got on the Zoom call. I think I told you this. I was like, super nervous. And they're like, yeah, looks good. Vaishali said, you're cool, talk about it. So we're good. I'm like, unbelievable. Okay. Why? And we talked about all kinds of things that, the patent term, the dependency reduction, et cetera, but super impressive team. The one thing I would say to you about pendency reduction is, as somebody who monetizes patents, and I often, get a portfolio late in life, I really like it when you open it up and there's a bunch of patent term extension on there and you get an extra 300 days. So I know what you're trying to do, but let's not be so good at it.
We're trying to reduce that. Sorry, Carl. We want to make sure that we, improve the PTA. So I don't know. I can't help you there.
Sorry. But either way, it's going to be 17 years before I see it. We would be disbarred if in 2024 we didn't talk about AI at a patent conference. So I know there's an executive order, mostly because your team told me. The administration put out an executive order on implementing AI across the government, and I know you guys have been at the forefront of it. How did you interpret the order, and what are you guys doing to implement it?
Yeah, so in the order, there was a lot of things that the USPTO, along with the Copyright Office, that we were tasked to do. And so as a result, one of the first things that we took, comments, and we created this, what is the inventorship guidelines. And basically, we were trying to look at the case law, determine what is the contribution that AI can provide, and what is and looking at it more from what is the contribution that the inventor provided. And so providing examples with regards to AI. We are also, another thing that came out, and this wasn't sort of in response to the executive order, but we were getting responses to briefs where people were using AI and they weren't checking the cases.
Ooh.
And so we put out guidance also that you have a duty to make sure that everything you submit at the USPTO that you verify and that what you're submitting is true. It is not to say that, you can't use these programs, but like you have to verify that the case law is correct. And so that was another thing we did. With regards to eligibility, we provided some more examples on eligibility, AI examples. And right now we're looking at POSITA and sort of when references use AI, what is that the prior art that can be used and things like that.
That's interesting. So person of ordinary skill in the art has to incorporate what contribution AI is making to the analysis.
Yeah, so I mean, there's a lot that's going on. And then we at the USPTO, we know that a lot of this work can't be done in a vacuum. We have the AI and emerging technology partnership program where we are having a lot of different events that we're trying to get the feedback from the public, the stakeholders, and things like that, so that we can make a very informed decision with regards to AI. And also, we're using AI within our own agency, our search systems. We have two functions that we've already deployed. One is it's called More Like This. More Like This. Basically, you have a search that comes up and you say, oh, I really like this reference. The examiner really likes it. And they push a button and it's going to provide references that are more like this. And then if another one is similarity search. And so it looks sort of at synonyms and finds, it pulls up, and those are AI models. We're doing design. It's called Design View, where there's also AI with regards to drawings. And this will not just help our design examiners, but maybe our mechanical examiners. So we're piloting that application. And then with regards to how we classify when a application comes in, we have the CPC classification that needs to be placed on the application. And we use contractors right now for that, but we're also trying to train the model to see what we can do using AI to create those classifications.
It seems to me that the use of AI at the office for prior art searching, as you described, is going to net increase the strength of the patents, because as someone who, and we both have worked defending, obviously HP got sued for patent infringement, and we defended people that got sued for patent infringement. And the first thing we do, obviously, is a prior art search. And back in the day, you'd find a whole host of prior art that just used different words to describe the same concept. And it feels like this has the opportunity to kind of close that loophole and be more fulsome in the examination or the uncovering of prior art at the office.
That's the hope, right? We want to make sure that we're issuing patents for things that are new, novel. There isn't prior art out there that discloses it.
Yeah. We're going to take questions in just a few minutes. For those of you online, I think you can submit through the Zoom, and then is that okay? And then Krista's going to submit or ask the question live, and obviously all of you are welcome to ask questions. I should have offered that earlier. You can interrupt us at any time. I know you can't comment on pending legislation. Can you comment on me commenting on pending legislation?
I can say interesting.
Okay. The thing that I find interesting about pending legislation, there's three that have been proposed in various times in 2024, and I wrote them down because I'll never remember them. But one is PARA, the Patent Eligibility Restoration Act. One is Restore, Patent Rights Act, and one is Prevail Act, which you can tell from the names how they're driving. And I think it's interesting. And I talked about the pendulum, which is on patent rights. All three of these pieces of proposed legislation would net increase the strength of a U.S. patent. Right. One deals with Alice, which we probably should talk about too, just because we would also be disbarred for not talking about Alice at an IP conference. The other one deals with trying to overturn or legislatively overturn the eBay case from 2006 that made injunctive relief for patentees more difficult and obvious and not automatic. And if that got restored, I think it would be super interesting. And then the Prevail Act deals with the number of times and the ways that a patent can be challenged at the PTAB through an IPR. So I'm excited because I think all the pending legislation is pushing us back in favor of a stronger U.S. patent. And I know you share that goal as commissioner of the Patent Office.
So I can't speak to actual legislation.
Get back door to get you to talk about it, wasn't it?
I can't speak to actual legislation that's out there. As the USPTO does play a role. If Congress comes to us, we will try to be experts, provide them information, and we love to work with them to help them in their initiatives. But at the same time, it is so critical that we do, our patent system is the strongest that it can be. And there's many ways, whether through legislation or whether it's internally working on, and my goal is what we need to do from an operational perspective to really try to make the patent system strong and make sure that we give the tools, like you were saying, that we can do the best searches we can, make sure we issue the right patents, and also make sure we give the training, continued training. Training is a huge thing at the USPTO that we do to make sure that they know the laws, they understand it, and that the quality of, our product are patents, and we want to make sure we have a good quality product. It's sort of the way I'm not answering your question, but I would love to talk about quality.
Yeah, you should.
So we do talk.
What do you when you say patent quality? What do you mean by that?
So I think it could take many different definitions. From a stakeholder perspective, right? When you get a patent, you want to know that you can take it, and whether you want to license it, you want to do infringement, or it provides value to your, the company. You want to know that it's worth the paper it's worth. It's worth a lot more than the paper it's written on. So I think that's important from a stakeholder perspective. From the USPTO, we want to make sure that we're following all the rules when it comes to issuing patents. And so we set sort of goals for ourselves, and we wanted to increase our compliance with the statutes 101, 102, 103, and 112, and we set targets. And how do we make sure that we're meeting those targets? We have the OPQA, that's the Office of Patent and Patent Quality Assurance. They will take randomly patents, and they will look, and they will do a second check. Were they meeting the requirements? And so they'll work with examiners. If something's not right, they will look to try to make corrections, talk with the managers. If they see trends in certain areas that we're seeing the same sort of mistakes, we'll do more training there. And so our long-term goals that we had set is that in each of these areas that we try to hit 94% compliance, but we've had to sort of creep up there. So last year we set our goal of 90, it was 94% for 101, 102, and 112, I believe. And then for 103, I'm sorry, it was 94% for 101, 102, and 112. We know that 103 is probably the one we need to, work on more and more. So that was set at 92%. We hit our targets. And so then now we've increased it to 93% for 103. And, by 2025 or 2026, we want to be 94% across the board.
That's kind of super ambitious to decrease patent pendency while increasing patent quality.
So look, many people think that the minute you start working on pendency, patent quality is going to go down. And it can happen. And that's why we have to be extremely, we can't take our eye off quality. And now, again, a lot of great work was done to improve the quality, and we set these targets for ourselves. the OPQA is still going to be there and making sure that we are meeting our requirements. We're also we have to be, if there's more applications that are going to be looked at, we have to increase the number of people working in OPQA. And that's not the only place. Managers have, when you are a junior examiner, your work is reviewed by your managers. So it doesn't just go out the door. It's not until you become a primary examiner and you get full SIG authority and you have to go through a whole full SIG program so that we have the confidence that you can sign on your own. The work is getting reviewed. And those people that also have the full signatory authority, their work gets reviewed by OPQA. We are going to continue our focus on quality. We are also going to make sure that we're looking at trends. If we're seeing anything that's a little bit off, we're going to do training, and we're going to be having our managers just also working together for that.
I love it when you talk about this stuff because I've been doing this for a year less than you have, and I'm fascinated by the amount of data that you pay attention to constantly advance these initiatives. So we should open the floor for questions. If you guys don't have questions, Carl has more, but they're not very on point. Atusa.
All right, so I might pass the microphone to folks over here, and then we'll get to some of the ones that are online.
Okay.
Also, the folks online here.
There's like 200 people on the internet watching Atusa.
Okay. Okay, thank you so much for this fascinating discussion. I did have one question. Interviews. So we've had a checkered experience, let's say, with interviews with US PTO examiners. Sometimes it goes really well and they really understand it. Sometimes they feel like somehow the patent practitioners are trying to pull the wool over their eyes and they're not quite so happy and they want it in writing. Are you encouraging interviews to increase the understanding between the attorneys and the examiners, or what is the trend regarding that?
We are not at any point saying like, oh, you cannot do interviews. I mean, and I think for different examiners, they operate different ways, right? So, but I do think interviews play a really good role of getting to sort of the ultimate goal that, allowance or making sure that from an examiner's perspective that they're meeting the requirements. Another, I will say, interesting thing that we are doing, clarity of the record is really important. So sometimes what's happening in the interview is not adequately delineated in the interview summary. So we're trying to make sure, we did a great program with AIPLA where we had practitioners come in and talk about the importance, like the cases where there was clarity of the record and how it really played a huge role in sort of the adjudication of the IP rights. And so we're also testing out a new interview summary form in we call it the R&D unit, where if there's new things we want to try out, we have a bunch of examiners in this R&D unit where they sort of see how these new forms could help. And so that it would, if there was what was really discussed. And the examiners are supposed to put that in their summary, but it also provides a sort of like a roadmap to help them provide that information in the interview summary. So we are looking at interviews, and we know that we want to make sure we also there is training to make sure that examiners are doing it in the proper way and things like that. So, but we haven't heard across the board that interviews are like horrible. But if we see that and we need more, feedback, and I'd love, like, if you want to provide any more feedback of what you're seeing. The other thing we want people to know, if you sort of hit a roadblock with an examiner, there's always that ability to go to the manager, the supervisory patent examiner.
Does that work, or is that like asking for the manager when you're out to eat?
But I think in certain situations you have to. I mean, I am not opposed to that. And again, I think our examiners are fantastic, and I think it should be few and far between, but it is not something that it isn't an option. So people should be aware.
One more question over here.
Yeah, my question is going back to the quality. I forget what the acronym was, the Office of Quality. So I'm a big fan of improving the quality. Is there any like effort to make that office to give greater clarity to it? Because I had an application that the examiner and the examiner allowed it, and then quality came back and said, hey, you need to have this, you should have made this rejection. So both the examiner and I felt like the rejection was, not proper. We didn't, but he had to make the rejection because quality said to make it. But so I'm now arguing, and quality's gone, right, from the process. He's now made the rejection, and kind of like, as somebody prosecuting an application, I feel like I'm in a weird spot because I'm not arguing with the person who made the rejection anymore. And I guess so that's like a irk, I guess, that I have. But in general, I just would like to see more clarity because I'm a very big fan of also examiners being able to live everywhere, because I have a friend who lives in Hudson and it's an examiner. And I called them and I was like, how does quality work? So I guess my long story short was, will there be an effort to provide more information to us about how quality works behind the scenes?
So just I guess, let me make sure I understand your question. So you want to understand like the whole OPQA process and have more clarity or transparency to that. And then if you disagree with the OPQA process, what is the mechanisms that are available? As to the second part, that's something I could take your information. I don't have that on hand, because that's not to say it doesn't happen, but this is the first time that I'm a question like that's come to me, and I can get more information on that. But as to the first one, if you actually just even go do a search for a USPTO and quality, there is a whole page dedicated to our OPQA group and how we also look at quality. There's a whole part of our website dedicated to that. So that gives a little bit more information there. But I do think that's a good point. Like, I think we're trying to get the word out of what we do on the quality side, and I think we need to do a better job there.
So we have a couple of questions online that are related to this topic as well. One person asked, would the office be open to considering changing petition practice so that it becomes a more meaningful avenue to perhaps respond to concerns around objections or anything like that? They wanted to know they said petition practice as it stands is often not used due simply to the fact that there's no holding the office accountable due to time constraints. So I'm not really sure exactly.
Oh, petition makes special? Is that what they're talking about?
Around petitions.
There's tons of different petitions. I guess that's why it's such a broad question. I mean, the amount. So that's what I'm trying to understand, like what petition is not working out. Like if it's petition to make special, I know that it's something that ends up on their docket and they're really, for docket management, like they have to meet certain guidelines, and I think we do a really good job making sure we hit those guidelines if we want to expedite things. But there's other types of petitions. So I guess some clarity.
I probably shouldn't have jumped in, because I didn't know there were more than one petition. Petition to make special is literally the only one I know of.
And I don't know there's a whole petitions group, right? And that deals with all the different types of petitions. And I wasn't familiar with all of them either, but I know when we transitioned to Patent Center, they talked about all the different petitions that we're working to make sure that they are easier for people to be able to use Patent Center. And so we have our timeline, but I can't list all of them.
We have one note that I'll want to make about the poll that just came up. For those online, answer the poll to get CLE credit. We have asked this poll question, what would you like to see the patent office focus on? And more than 52% said the speed and timing of patent issuance. A few said design patent reform. New technologies like AI and incorporating that is another large thing that people seem to be interested in, and support for small and underrepresented inventors. One that we haven't really talked about is how the patent office has been trying to increase or have more programs to help small and underrepresented vendors. Can you tell us a little bit about those?
So I think the USPTO, we want to, and this is under the direction of, and I'm not saying previous directors didn't care about this or not, but Kathy Badal, I think, has done such a fabulous job to make sure that increasing access to the innovation ecosystem and making sure that all people, stakeholders can be a part of that ecosystem. And a lot of that is providing accessibility. So just a couple things that we have implemented. And one, she set up WE, which is a women's entrepreneurship initiative. It's not just for women. Anyone can go on this. If you look up WE and USPTO, it is beneficial for anyone trying to get into the innovation ecosystem. But it talks about people need to know simply what is their IP. So there, we set up an IP identifier. You can answer a bunch of questions, and it tells you all the different IP you can have. And for us who are probably practitioners, that's something like we take for granted. We know what that is, but many people out there don't. So we provide this. And then it's also important to funding. And so a pillar of that is, how to get the funding that you need. And finally, it's building your networks, getting access to the people that might help you. So that whole initiative is out there. And also we, even with the way that, for example, patents, think about this, or there was data that was out there that said that when you get rejection, women would see that as it's over, or maybe someone who's not as much experience, they would just say, I'm rejected. I can't get my patent. And so what we did is we incorporated a welcome letter. So it provided all the different assistance you can get with regards to legal, if you don't have funding, what are the different things, programs that we have if you have questions. So made it just be the first part. So you have that welcome letter when you file your patent. And then afterwards, when you get the first rejection, we are now in the process of testing out another letter explaining, what does this mean? This doesn't mean it's over, that it's done. And so we are testing it out with a small group to see what the return on investment of a letter like that. So there's a lot of different initiatives. We also did the pre-prosecution pilot, where we are enable people who meet the certain, like the small or micro entity status, that they can come in. I don't believe it's small. It's the micro. They have to meet some sort of economic thresholds. They can come in and they can just understand how to do a search, so that they can see and provide guidance on like the filing the patent process. So that's also happening too, that we just recently implemented this year.
That's fantastic. Sounds like it'll make it way more accessible. We had another question over here in the audience.
Good morning, Vishali and Carl. Thank you for being here. My name is Bree King. I'm a 3LP at Cleveland State. Professor Laser is my supervisor for the paper I'm writing. So I have a kind of two-part question. So one, of those 1,600 examiner jobs, how many do you, or if you know, are allocated for design versus utility?
None of those are allocated for design because we have a whole other quota for design. I think our target for design examiners are approximately, I know last year we had 50, and I think that number is either going to be 50 design examiners or even more. The filings for design applications are through the roof. So we had a 20% increase in design filings just this past year. So we know we need to bring in even more design examiners too.
Is that Apple Samsung driven, or why do you think that is?
I think, I think there's, I mean, it's just understanding. So we've tried to do is at the USPTO more recently, we tried to elevate designs, and we actually, we have technology centers, and the designs was underneath like one of the deputies. We actually pulled it out And we now have a deputy of design because there are some things that are very unique with designs that doesn't apply to utility and some things that overlap. So we wanted to make sure that we could sort of elevate designs, make sure that the issues that were happening in designs were happening. The trends, I mean, I think that people are just seeing the value of design patents and that, you know, it is something that in many of the, you know, whatever you're doing in the utility sign, there's something you could probably be doing to protect yourself, you know, that design patents could also play and people are seeing that.
Okay.
Okay, second part. Oh,
Yeah, I was saying, then the second part, so before going to law school, like this wasn't my plan. I didn't think I would be here. But now that I am here, it's really disheartening to know that because I don't have this science background, I can't do the utility. And so it would be my end to come on in design. So my question is, do you think like in the future there might be some workaround, like they might, I don't know, change something to maybe allow people that after they've practiced in design to come over to utility? I have a really strong interest in marijuana law right now. And I would love to protect people that are making these, I don't know, crazy cross strands, but that is more on the scientific side, not their packaging. So yeah, I guess that's my second question.
So at this time, we don't, the requirement is that you have to have not necessarily a science and engineering degree, but also like coursework in those areas or experience that you can say that would apply in those areas. But I mean, we did expand the design bar so that it could be more open. So for people who didn't have a technical degree, so not now. I don't see that just yet happening. I will say in the patent world, so often there is this view that, you know, having the technical degree will make you the best patent attorney. I think it provides some value, but some of the best litigators that I worked with didn't have a technical degree. People that worked for me had English degrees, and then people I was mentored by had, you know, non-technical degrees. They understood patent law, and so I think don't get discouraged that you don't have a technical degree.
I think I'm glad you said that. It's a bit of a misnomer that comes from when you're in law school because all the people that have technical degrees are drawn to patent law, but it's such a broad practice that it's only for prosecution where you need to have a technical degree. In this room is the retired former head of the IP litigation department at Jones Day, who likes to joke that he was a single E. So he had an English degree, and a fabulous trial lawyer led the Jones Day IP litigation practice. And there's a current partner at Jones Day in the room too that's got a degree in. He majored in football at Northwestern. I'm not sure exactly what his degree is, but I know it wasn't engineering. And so there's all kinds of career opportunities out there for non-technical folks in the IP space. It's just the prosecution piece that you can't do. That's it.
Yeah, and there's trademark examiner positions too.
We have one more question in the audience, and then we can try to wrap it up after that.
Yeah, so my question is about, you were mentioning individuals who are interested in becoming a PTO examiner. My current background is mechanical engineering, but I'm considering pursuing an additional technical degree. Do you have, will I be stuck with one prior art or art unit or if I acquire additional like technical degree, like it'll expand. I could practice in different art units.
So once when you apply, you have to meet certain requirements. So if you go on our website, we tried to also say, like, if you have these degrees, you can apply. Because we have 9 different openings, like one that says, you know, physics, one that says EE, computer science. So it'll tell you, we have a roadmap, like if you have this degree, you can come in. Once you're in, there is ability to move. We have this thing that we set up last year. It's called that technology marketplace because there's certain areas that we need examiners to move into. There's a high docket, and we're open to allowing people to move into those high docket areas, giving them sort of the training that they need, and also giving them the learning curve they need to become successful in those areas. So that is available.
I can't imagine with a mechanical engineering degree that you would need more schooling, but I could be wrong about that. Gotcha. Oh, gotcha.
it sounds like, and I think one last question to kind of wrap that up. It sounds like we have a lot of people in the audience that have this interest in maybe becoming a patent examiner. Can you say what are the basic requirements for becoming a patent examiner, and what do you guys most look for when trying to hire a new patent examiner?
So I guess my advice for people trying to become a patent examiner. Well, first I will say we tried to change we just put this out. If you went on last year and read the job posting, it was so hard to understand what a patent examiner needed to do and what what were the requirements and things like that. We had plain language person review it. We made it a lot more like understandable. And so hopefully it reads a lot better. But you need to have a technical degree or coursework, and there's requirements like you go in there and you can click on a link and it will tell you all the requirements you have with regards to coursework. You don't need a law degree. If you have that engineering degree or science degree or that experience, you can qualify. I think it's really important. I will say last year we had 40,000 people apply to be a patent examiner. When we changed the job posting in just 2 months, we've had 20,000 people apply for a patent examiner. What is really, really important to understand is so often I think people say, oh, I just had a small exposure to this area in my coursework, so I don't have a lot of experience there, so they don't check the box. As you realize when you come in, even that small exposure to that area matters, and people will get put in that area if it's a high docket area. So check all the boxes, make sure, if you haven't had any experience, don't check the box. But if you've had some experience in certain areas, check the box. And because there's, any type of, when you have so many applications, there's a process that we see, like, oh, these people had this much experience, so they're going to be rated at a higher thing. And it's just from what information you provide. And then if we meet the requirements from that group of people, then, the job posting's closed.
I think we can wrap up the panel. Thank you so much. Carl, if you want to do one last note or.
No, that was it. I was going to say, I'm glad we ended on the note of Cleveland Marshall students should think about applying to be patent examiners, because it's a perfect ending for a talk here. Vaishali, thank you so much for coming.
Yeah, thank you, Carl.
Look forward to seeing how this develops, because I think what you talked about today and the way you're implementing the programs that are going to lead to better patent quality and shorter pendency is unbelievable, and I'm excited for you. Thanks for coming.
Thank you.
Perfect. So welcome to the next panel. This panel is on healthcare and intellectual property. Healthcare is an area of law where intellectual property can play a huge impact in driving innovation and commercialization of inventions. Here on this panel today, we have some incredible inventors who are local that are going to talk about some of their inventions and their experience with the process. Then we also have from Cleveland Clinic some licensing experience and experience with what do you do once you have that patent and you're trying to change companies. And we also have from the VC space looking at what do we do when we're going to be selling companies that have healthcare as the main section of their portfolio and perhaps have patents in that space. Co-moderating with me is the incredible Ari Sherwin, who is a co-chair and has been a co-chair and supporter of this conference since the very beginning and always puts such huge effort into helping to make sure we get amazing speakers and amazing content. So I'll turn it over to Ari to introduce our inventors.
All right, great. Thanks, Krista. Good morning. Glad you could be here. And very quickly, we'll make some introductions and then hit the subject matter. So Dr. Dave Heeman, Metro Health inventor specializing in podiatry and issues relating to feet and ankle conditions. And anything else you'd like to add to that in terms of your background? All right, perfect. Ted Theophrastus is a partner at Corman Jackson & Krantz is a lawyer, of course, also an entrepreneur, has been involved with Case Western Reserve University's Venture IP Clinic, and acts as outside counsel for Metro Health handling tech transfer. Anything else you'd like to add to that, Ted? All right, terrific. And we'll get back to the two of you in just a moment.
And then introducing Dr. Deborah Hemingway, who is the managing partner at Ekphora Capital, who focuses on medical technologies. And is there anything you'd want to add to your intro? No. And then we also have Partha Paul, who's in business development and licensing at Cleveland Clinic, as well as brings a wealth of experience in licensing throughout the rest of his career as well. Anything you'd like to add? Okay, we'll get started by talking with the inventors first.
All right, great. Thanks, Krista. All right, let's jump right in. Dr. Heeman, first, just tell us about one or other inventions of yours, and in particular, how you went about the ideation process, how you conceived of the invention, and we'll kind of take it from there.
So the kind of invention I've worked on is this right here. It's a subcutaneous fusion jig. And it was actually born out of a case working with residents and having seen residents struggle with this part of the procedure, not only reducing the deformity that we're trying to address, but the larger rate, and just realizing it's something that should take 5 or 10 minutes.
There we go. Better. So as I was saying, this was kind of born out of working with residents and watching them struggle. Something that should take maybe 5 or 10 minutes to put the hardware in was taking 45 minutes to an hour. And when you're talking about OR time, we're talking about $60 a minute. So significant difference in not only efficiency and what it's doing medically to the patient with extended anesthesia exposure, but also in this day and age, everybody's looking for cost cutting and trying to be efficient. And after a frustrating case, literally went home and drew it out on a sheet of paper, like sketched it, and then started the whole process of trying to figure out what do I need to do for next steps.
All right, great. And in terms of doing your due diligence, I'm assuming you had some sort of knowledge or did some research in terms of third party.
So some friends of ours knew a lawyer outside of Metro. I reached out to them, briefly spoke to them, and then was advised your hospital probably has an IP policy. You may want to check with them first.
Smart.
Because I had no knowledge in all reality. So went through the steps of finding out what our IP policy was, and then reached out to counsel, and then was introduced to Ted and his group.
All right, great. We'll get to Ted in a moment. That actually reminds me of a story. I'm at Sherwin-Williams now, but when I was in private practice, walked into our office an independent inventor and had a great idea relating to a battery. And I was excited to bring him in. I was a young associate, was ready to write a check for retainer, and I went to the partner. And of course, the partner asked, what was the basic subject matter of the invention? Oh, it's a battery. And what's this guy doing? Oh, he's in between jobs. What was his last job? Oh, he was at Eveready. And the partner said, no, we're not going to take on that new client. So smart that you went to the legal resources first. So Ted, how did you become involved and what did you do to help Dr. Heeman?
So my background, I've been on both sides of the table. I was in-house at the Cleveland Clinic years ago as chief commercialization counsel and teach at CASA in a commercialization program. And for me, at least, the recurring lesson that I and other teams have learned is don't do the ready, fire, aim thing. Try to take a look. Try to be careful about what the potential is, both for IP protection, but also, is there a market potential? How far away are you from real proof of concept? How much data is going to be required to get to the next milestone where you might be able to get outside funding? So my team works with academic medical centers as really outside tech transfer for groups that are, they have research, but they don't have a full team. A full team can be an expensive proposition, and frankly,
Metro is actually a really wonderful institution, but it's a subdivision of county government, and they just don't have a budget. And I guess I would say to some degree that the number of inventions that would really support an in-house team. So what we do is very similar to other organizations. There's an invention disclosure process. We have a case manager who works with the inventor, and that's where we try to flesh out like what do we need to know in order to make these decisions. We put together an opportunity assessment for senior leadership, and it's kind of baby steps. Should we file any kind of patent application? And in this case, putting together a provisional based on the invention disclosure, it's kind of a no-brainer. To the extent we can get to a non-functional or even functional prototype, try to get there as quickly as we can. And, I may lean more heavily in this direction than some, but I find when you're talking with industry and you can show them what you're thinking of and not having to spend, an inordinate amount of cash to do that, it's a good strategy. Bring them in as early as you can with that provisional filed, have an NDA that allows you to speak freely, mutually protective NDA. And if you're lucky, they'll be receptive and maybe want to be part of the development. And so in this case, Dave really had a very good, but kind of a napkin sketch of what he was wanting to do. And he knew the dimensions. It was all up here. So we engaged with an outside designer to put together a 3D model. And frankly, we used ThinkBox at Case Western to do a very nice non-functional prototype. And if you've ever done old 3D printing or low-end 3D printing, it's good, but it's not very durable, and it's much less functional. This is a higher end polymer. It's on the machines you can't operate yourself at Case, but
It's pretty rigid. I mean, it's pretty stable. It was stable enough that I could play with it and figure out, well, actually, we need to tweak this or this. And then was able to use it on like a fake phone model. So
no, and Dave's, honestly, the other part of this that is hard to generalize, but, a very motivated inventor who knows where the value is. So we gave him the parts and he screwed the whole thing together and had it ready to go, almost immediately. But with this, we can sit down, and again, we have engaged with one device manufacturer who is very interested. They were actually pretty grateful that we pulled them in. And you can really see how it works. And, that with a solid IP platform that they've had a voice in and a path toward the next level of validation and data collection is a pretty good mix of variables to try to get, some kind of collaboration in place.
That's great. And actually, Dave, you touched upon it. In terms of prototyping, I'm sure you came up with different iterations or ideas to build upon once you actually engage with various testing, and also assuming you worked with Ted in terms of feeding him with data to substantiate the invention.
that was probably the hardest challenge initially, was just trying to relate to them. This is what the device is designed to do. Here's how it's a benefit to the industry, and the importance of it, and why I think we have like a good product here. But just simply trying to relate what I do to somebody with zero experience in that field can be challenging.
Sure. And to allow enough time for the other panels too, but I would like to at least finish up with this portion of the topic. And of course, the two of you are welcome to chime in as we progress. But were there discussions ever had? Because I know with these types of inventions, there are multiple facets, and sometimes you can protect certain portions with a patent, other parts with trade secrets. If you wouldn't mind touching upon that.
Yeah,
You can.
we try to use the whole toolbox if we can. And, some things lend themselves better to, for instance, trade secret protection. If it's cloud-based software and it's very clever, that's a good place to use that. In this case, there are other devices that work even on the same procedure, but not this way. And so we've got a pretty good functional path. And again, by bringing in industry early, even showing them the provisional, prior to conversion, they'll tell us what they think needs to be in there as well. And, again, it's not, there are no strings on any of that, but if we can come to agreement on what it ought to look like, the likelihood of us, being able to hand it over to them for commercialization is higher.
All right, great. No, thank you very much. All right, this time I'm going to hand the baton back to Krista. We'll take it from there. Thanks.
So I hope that all of you guys will chime in on many of these, but our panelists also include folks that have experience with licensing and with selling patented technology. What have you found to be some of the most important considerations for intellectual property in the med tech space? And how important is IP in this field when it comes to something like selling a company or when it comes to deriving value from an invention through licensing?
All right, I'll kick this off. So for us at my firm, we're dealing with really early stage medical device companies. What this means is that the companies are pre-FDA, and so they have generally a long and expensive regulatory process they need to get through. So what we are doing is we're decreasing the risk as much as we can, because in venture capital, we're dealing with private equity. So to take a step back, in venture capital, we are dealing with very early, very high risk companies. If you want to purchase a part of a company on a public market, you can go and do that, and you can buy and sell your ownership in the company freely. However, in the private markets, when we make an investment, it's completely illiquid. So we're purchasing, and we won't have access to that capital potentially ever if the company goes under, or at least if we get a return, it'll be upon an exit, like a merger and acquisition in most cases. So whenever we go in, we have to be very, very confident in the company. And at my firm, there's 4 things that we look at. The first one is the product market fit. That's who's buying it. The next was the technical feasibility, meaning, does it technically work? And the third thing, so out of our top 4, the third thing that we look at is the patents. We are looking at the patent portfolio, and we want to see how much protection they have. And then finally, we're looking at the exit strategy. So at what price point we can expect an exit and what time frame. And that patent piece is so important. It's absolutely critical, especially in these really early stages, because when you're pouring multiple millions of dollars into these companies, you're doing so to get them to market, and you do need that protection for the companies throughout the journey. If you don't have protection, it's not a fundable business.
Any additions, Parth?
Yeah, so at Cleveland Clinic, obviously we have very early stage technologies. Okay. Now, we can probably, decide whose technologies that are earlier, what you see or what we see. But, with those inventions which we are getting, few of those will form some new companies, spin those off. But many of the other ones, we will try to de-risk some of these through development of the technology further, enabling those inventions, and then filing for IP protection. So IP certainly in the medtech space, and especially in the device space. Okay, some of the software is a little different, but hard devices, it becomes a very important part of creating the value and deriving value from the invention.
Partha, maybe you can walk us through. I know that your role at Cleveland Clinic involves work on out licensing, meaning that you're taking inventions that happen at the clinic and trying to license those out to startups or other companies that are then going to commercialize it. What is your process when it comes to out licensing, and how do you determine what companies you're going to out license to?
Okay, so let me describe the process in a little bit more detail here. So we get probably around 300 or so invention disclosures on a yearly fashion. So we have a team in the innovations department, which is split up into 5 different parts, right? So there is one which is early stage engagement with the inventors, guiding them through the process of filing the invention disclosure, making sure they are hitting the kind of right points on the invention disclosures. Then we have a assessment team who is looking at IP assessment as well as market assessment. Then we have a development team, who is guiding the inventors through the development and trying to enable some of those inventions. And then we come in when we believe that the invention is at a stage where we can go and talk to the industry and see if we can seek partnerships, okay, there. And then we have a new company creation group who is looking at few of these inventions where they can form individual standalone companies out of those inventions. So when we are looking at uh, potential partners, obviously, what is important for us to have a good feel for what the invention really is, what the technology is, what the value proposition is, where does it fit in the patient treatment or care paradigm, which companies are really involved in their trying to understand their portfolio and how this product might, or this invention slash product might find its way into their portfolio so that it enhances their portfolio. So we generally have a long list of mature companies as well as early stage companies. We engage with them, discuss, and actually Ted and I were talking about, early stage relationship with larger companies, and we take it through this process and try to make sure that we have the right even CD confidentiality agreement and those things are in place so that we can discuss with the companies in great detail.
I know one thing that you mentioned, and maybe this was when we were talking earlier, is that one of the goals for Cleveland Clinic is trying to make sure that the patents that you guys are licensing out are going to a place that's going to actually commercialize that and be successful in commercializing it so that it gets to patients. Is that right?
That is the key driver for us. Okay, what we want to see are these inventions which could find its place in treating patients or diagnosing patients, whatever that might be. So the way we treat all of our licenses, we are very careful about clearly documenting what the development path would be and what the development timelines are. And we try to follow those very clearly and diligently so that we can show that this invention is moving through the development process with the hope that it will be available for patient care.
And this is a question for all of our other panelists too. I mean, how do you make sure that you're drafting a license or creating partnerships that help to make sure that this is not going to be a startup killer of a license and that you're actually going to get a lot of positive benefits for both parties, both the inventor and the company? Do others have thoughts on this?
Well, I certainly do. All right. Okay, so when you're dealing with these early stage companies, it's hyper competitive. We need hyper aggression. The company is anywhere from 6 months to 0 months away from going under. And when you're dealing with getting the foundation of the company right, there are certain things that you can do up front that will make it unlikely that anyone's going to purchase your company. And there's certain things that you can do to increase the likelihood of someone purchasing your company, because it's, in the end, all about risk and reward. If your company is too risky, you're not going to be able to attract any capital because people think, what, if they invest in your company, it's going to go under and they're going to lose all their money. Okay, so what can you do to increase the likelihood of being acquired? And one of the things that you can do is get a very friendly term sheet up front. And we don't always see that coming out of, I've not dealt with Cleveland Clinic, so I'm sure that they are absolutely wonderful, but not all institutions are like that. And some institutions that we see are more concerned with research and don't have that interest in seeing their innovation going to clinic and don't have, concern for the commercialization piece. And so dealing with an institution like that, we do see terms that are non-starters for the really early stages. So it does vary by institution. you want me to elaborate?
What are some of those terms that you
Okay.
feel like are
Oh, no.
pillars?
Okay.
You would never
Yeah.
do something with that term.
Okay, so my firm would never, and I would never recommend this for anyone, and I apologize if you guys do this. I would never agree to a term that says you owe us royalties. So this is coming from the licensing institution telling the startup, you owe us royalties for time and all eternity, even after the patent expires, the base patent. Okay, so and that's completely a non-starter because that is going to completely kill a potential acquirer from wanting to purchase your company. If they do purchase it, they're just going to go in and purchase all the assets out and, try to get out of that clause because why should, a acquiring company, be tied to something that others in the market are not. So that is one that would be a non-starter. Another one would be, and that is something I have seen before, by the way, that's not a hypothetical situation. Another one would be, we own 5% of the company equity, but our equity piece is non-dilutable. So you're going to raise capital, but you're not going to dilute out our shares. You're going to dilute out everyone else's. That is also a non-starter.
And so for students who are here and they're wondering, okay, what is all this? What is this dilution or non-dilution of capital? Basically, they're saying that if there's, let's say, a company that has a patent and they're licensing it, and they say we own 5% of the company that we're licensing this patent to, and you can't dilute us, that means that that company would not be able to raise as effectively new money later on, because normally when you're raising new money, all of the other ownership, all the other equity is going to go down based on how much additional you add in. So saying that a non-dilution clause or saying we keep 5% even though we don't put more in, that's basically restricting the ability of other investors to make sure that they're getting their money's worth for their investments in the future.
So Deborah, on the other side, what
Here we go.
Let's hear the other side.
what we also see sometimes industry saying that you will get royalty for 7 years after the product is launched, till 7 years after the product is launched. Okay. So my comment always is, okay, fine, I can understand you're not going to pay royalty for eternity, but pay me royalty till the last claim is still active, right?
We can talk. We can talk about that.
Does the inventor have any thoughts on this?
Yeah, so I would say there are a lot of tools in the toolbox. And and it's confusing because in the venture capital world, anti-dilution means something very different than what an institution means when they want an undilutable position. Usually that does make sense if there's a next funding milestone, particularly with a very early stage company, because in essence, what you're saying is we're going to hold you to it. So you raise, and it needs to be negotiated thoughtfully, like, is that exactly how much money you're going to raise? But it doesn't have to be a very high bar. Like, for instance, Case Western will use $1 or $2 million. You need to raise $1 or $2 million. And until you do, as you're issuing stock options and additional stock inside the company, do whatever you want. But we're going to keep our 5%. But as soon as that threshold's crossed, then it goes away, which I think it has to. The other thing I'll say on
That would be reasonable.
Yeah, no, honestly, it is to some degree, it just makes it easy. So you're not having to micromanage the cap table of a very early startup. I'd say on the forever royalty thing, next time you hear that, I would just pound the table and say, that's patent misuse and it's illegal and you can't, it is. And, there are workarounds of tying know-how and so forth, but it's a real issue. You really can't do that. For me, the best licensee is one who really has a vision of how they're going to get to market. And so pretty early, I'll be negotiating really with a spreadsheet. What do you think the revenue potential is? What's your cost structure? How does that relate to industry? Show me how you're going to get to, if we have to go through clinical trials, how are you going to get to the first trial? How much capital do you need to get there? And if they can answer those questions, one, it shows they know what they're talking about, but two, now we're in the model. We're not in an abstraction. So we're not going to say just arbitrarily, it's going to be a 3.5% royalty. We'll say the net present value or discounted future cash flows, however you want to handle it, it conforms to industry standards relative to the royalty. So the royalty is a function of that plan. And really importantly, we can also play another tool for not-for-profits that they really can't do a deal for any less than fair market value. They can't. I mean, to be a tax exempt, you can't dispose of an asset for less than its value. So if a licensee comes back and says, we only want to pay royalties for 3 years, my reaction would be, well, we just did the model. You see what we should be getting out of this. Tell me how else you're going to do it, because you're welcome to pay it all up front if you'd like, which nobody wants to do. But again, I think the road mapping and the confidence building around both sides being aligned of where we're going and how we're going to get there is the best indicator of a licensee, a good licensee.
Now, one interesting thing in the medtech biotech space is that there are some areas where patents play a huge role in preventing competition and ensuring commercial success, and other areas where they might not. So pharmaceuticals, for example, is one place where you see patents playing a huge role, probably 100%, I'd say, importance on whether you can get a patent will affect how your pharmaceutical company does. But that might not be true in other areas. Can you guys talk about how important a patent is in the medtech area and different subgenres of medtech?
Sure, I'll kick this off. So sometimes we'll see like a product, a health tech product that's going direct to consumer, maybe it's an app, a software play, or something that can go to market, very quickly and doesn't have this huge regulatory burden. And so that might not be as dependent on having a very strong, robust patent portfolio, patent landscape. Might be much more clear in that scenario. For us, I'd say med tech, especially my firm, we're somewhere in the middle between like the needs of pharma play and the no patent needs. We'll see a base patent come out of an institution most times, but then like that base patent may or may not actually have such a critical component in the final product as it goes to market. So sometimes it does, but a lot of times there's so much iteration that happens after you make that bridge from a government or an academic lab, to becoming a commercially viable product. I see that amount of time is often underestimated as to the amount of work that will go into making a commercially ready product. So sometimes we don't even see the initial innovation being a part of the final product. And sometimes it is, but oftentimes.
Others have thoughts on this?
Yeah, so many of the, I would say, hard medical devices where you have some mechanical component or electrical components in it, there, I think IP patents play a very huge role, okay? We also see some inventions in the more on the software side and some on the AI side, where some of these AI tools which are being used, they are black box kind of AI algorithms where there is not a very clear understanding how we can seek even patent protection. Okay, and a disclaimer: I'm not an IP lawyer, so some of these things with what I'm talking about, you have to take it with a grain of salt. So, but if I let's say look at a specific area where there are a lot of AI tools in imaging. These are analysis of images. It can be MRI, it can be CT, it can be ultrasound, X-ray, whatever it is. There are a number of products which are coming out, and I think if you look at the industry, there are probably 100 companies who are developing products in that specific space. Right? Many of these products are not that well protected or not protected at all with IP. They always have know-how. They have trade secret and things like that. But and part of it happens also what Deborah was talking about, that the life cycle of development is short. You can get the product out quickly. So most of these products are approved through a 510(k) process. So the regulatory cycle is also quite short. But it has, I see this not having IP as a pros and cons also, because it has enabled multiple companies to be present in the marketplace. However, it also increases the competition, and I do not know from a business perspective how viable all these 100 companies will be. Okay, there will be, I could see massive amount of consolidation happening in that industry or that specific part of the industry. So those are my views about IP in some of the software related things versus hardcore mechanical and electrical medical devices.
I might have Ted respond briefly, and then I actually have a question for Dr. Heyman after that too.
Yeah, so just relative to the value of patents in life sciences, it really honestly depends on what you're taking to market. If it is a pharmaceutical, you're talking many years before there'll be any revenue, and you're burning patent life during the entire process. If you're going through 3 phases of clinical trials, you're talking potentially hundreds of millions of dollars with a single-digit likelihood of success. I mean, it's very low levels of success because you've got to prove both safety and efficacy, and you may be at this point only dealing with a very small amount of animal data. So the better the patent protection, the more likely you're going to be able to raise those hundreds of millions of dollars because you have a comprehensive asset that reflects the product. The big question is, does the patent as issued, do the claims actually reflect the product? And that can really be surprising that it oftentimes doesn't. By the time you get through prosecution, there's a battle for something to issue. Question is, does that actually reflect, particularly in the device field, is it really comprehensive enough to cover what we're doing? It's compounded by the fact that most of our research institutions here are doing basic research. So their inventions are not typically a product. That's a phenomenon or a compound or, something that at least is going to need a delivery mechanism or a lot more, of a design around it. So it's critically important, but the quality is as important. And there has to be a strategy for building around that. But to Deborah's point of, once you discover all those other things, really continuing to try to protect in concentric circles around whatever that core is.
And Dr. Heyman, how important would you say that having the availability of patent protection for the type of invention that you created, how important was that to your incentives to actually continue to pursue that and to develop it? Do you think that you would have pursued it if there hadn't been a patent protection available to you?
I mean, I still would have tried to pursue it, but knowing what's out there in industry, knowing, the profitability potential, it's extremely important. I do have some colleagues that have taken products to market before, and basically every person, the advice they gave to me was get that patent.
Yeah, well, the benefit of having those patents is that it's providing exclusivity that allows you to be the one to invest in the commercialization and development, which you might not have the incentives to do if there are vast numbers of other companies, for example, in the imaging space, that are doing the same thing.
I will also say this, Metro Health, I think, is very generous in their IP policy as far as how it reflects back to the inventor. Whereas I have heard some other institutes, it's not quite that way. And that would personally deter me, honestly, because it's a lot of work to go through this.
There are some states where there are some added protections that are required for inventors that invent at an institution. For example, not allowing contracts that would automatically transfer ownership of that to your institution unless there are certain very particular requirements met, such as that being right within the scope of your work for the institution. So it might be helpful for, perhaps Ohio to explore something like that to help incentivize inventorship. Ted?
Well, and I would just say to Dave's point, you're right. It does vary by institution, by state. We just did a national survey of really the sort of preeminent, highly successful universities and even the smaller private institutions that don't have as much going on. And the amount of variability, the frameworks are the same, but the variables are pretty different. But the reality is, whatever the state law is, particularly with federally sponsored research, unless they want to get out of the Bayh-Dole Act framework, they kind of have to buy into this idea that the university is going to run with it. And, you know, the question is how much the inventor actually gets back at the end of the day. Can they hold equity directly? Is there a step down after the first money's paid in? There's a lot to look at.
So Cleveland does have a lot of advantages for innovators, I think, especially in the med tech space. Maybe you guys can tell me a little bit about what Cleveland has that makes it such a potential hub for innovation in med tech. And I'll direct this to the Clevelanders and then talk about Deborah's experience outside of Cleveland.
I mean, I think just in general, there's 3 very good medical institutes here in Cleveland, and that in itself is going to drive innovation.
I'd say also I mean, I guess you could almost call it incestuous, but it's a highly collaborative set of relationships between the major institutions. So most people at Metro Health, most staff members who are practicing clinically have some kind of affiliation with another institution, many of them at Case Western, some at the VA. We're routinely getting invention disclosures where it's the clinic, the VA, UH, Case, I mean, it's everybody. And some of them are wearing multiple hats, so we have to figure out how the royalty split's going to work. But that means that cross-pollination means you're not limited to, you know, this sort of strict lane that your institution's in. You might have a role you're going to play in a larger project that's pretty specific, but it's very welcome. And putting in interinstitutional agreements is very normal. The other thing I'll say here is our early stage ecosystem is as good as any place in the world. We're not so good at B, C, D rounds for venture financing, but to get something off the ground and get your first, let's say, certainly $1 million, if not $5 million in capital is an achievable goal here. And there's a lot of, the state has invested heavily in having entrepreneurial resources, whether it's mentoring or, you know, even like the I-Corps program that's running out of the University of Akron. Those things are made essentially free to the entrepreneur. And particularly if they're very heavy on the science, but they really don't understand business, that can be a real accelerator.
And Deborah, I'm curious because you come from a different environment in Baltimore where there are very different state incentives towards innovation. Can you tell us about some of those incentives that are offered, like the tax breaks and other programs, and anything else that you think really contributes to the access to capital there?
Great. And how long do I have to answer this question?
Let's go a few more minutes, and then we'll open it up to audience questions.
Okay. So Maryland, in some ways there are similarities, to the Baltimore DC region, and this region. There's a lot of innovation here. That we have to see a lot of it in Maryland as well. It's some fantastic medical research, academic, government institutions in our state. What we have is also this missing piece of commercialization. So we have the innovation, but then what? Right? You have all these amazing startups, and then what? So in Maryland, we had seen, historically our startups forming in Maryland, but then leaving and going to some of the more traditional med tech and biotech hotspots, meaning specifically Boston is the big draw for us, losing a lot of companies to Boston ecosystem, and then also the West Coast. So almost 20 years ago, so in 2005, the legislators noticed this problem and they came up with a tax credit program. This program has been very successful in Maryland. I'm happy to go into details if you want to establish a similar one here in Ohio. I can tell you more about my experience. But in short, what it does is it encourages startups to remain in the state. It not only encourages, it requires them. So if a startup participates in the program, they must remain in the state of Maryland for at least 3 years, with the hope that they stay indefinitely. So that's on the startup side. On the investor side, what the state does is it offsets the downside risk for the investors in terms of providing a tax credit for the investors. So the tax credit is based on the amount of money that you put into the company. So the investors are incentivized to put more money into the companies, and it's easier for the companies to raise money because they can tell the investors, hey, if you invest in our startup, most startups, you could lose all your money. But in here, you're at least going to get a portion of your investment back via our participation in the state tax credit program. So for my firm, we have the top level of the program. This means that we're able to give a 75% tax credit to the investors. So for us, whenever we put $1 million in, we're giving $750,000 of that. We get that back in tax credits. So it's a very strong and very compelling program. Investors love it because now they're not at a complete and total loss of all assets. And the startups love it because, yes, they'll be in Maryland and they're happy to do that. But also it's much easier to both raise capital and raise more capital from existing investors.
And by keeping that capital in the state, you're creating the kind of ecosystems that are what draws people to the West Coast and the other areas, because it's the amount of wins that people get. They're getting back a lot of money from previous startups and reinvesting it in new startups, and you can't get that if people leave. So creating those tax incentives to keep people in the state is great, and I think could be really useful for Cleveland and in the economic opportunity zones that are in Cleveland. So with that, I think I'll open it up to audience questions if folks have thoughts. All right, I think
we do.
Oh yeah, just Ari.
Let's, before we open up to questions, I just want to come full circle and wrap it up at least formally with Dr. Heeman, since the basis of innovation is our foundation of inventors. So what advice would you give to a young inventor who's working on, whether it's, healthcare, med tech, or otherwise related to another technology, before they actually start the IP process, commercialization, testing? If you had to tell someone who's new, what would you say?
Getting a mentor is highly beneficial. Just being able to rely on them, saying, what process did you go through? What does this course look like? What should I expect? Was extremely beneficial. And then also, if it's someone you trust, I kind of pitch the idea, hey, does this seem reasonable? Does this have some legs? Or, am I just dreaming something up that's not going to be applicable to our field?
With an NDA.
Well, that's also before you have any knowledge of any of that, but yes, an NDA.
Sure. And actually, Ted, to piggyback that, what advice would you give to a young attorney or consultant working with a new inventor?
Well, I was struck by the comment in the earlier panel of, I don't have the tech background to do this. The reality is, I believe, being an effective lawyer to business clients and research clients is a moving target. And you can't be parochial about what you're willing to understand. You may not understand everything, but the business case matters. The ability to understand even just the basic fundamentals of, for instance, in life science, like reimbursement, understanding who actually pays. Life science is unusual in that regard, that the patient is, technically paying, but it's oftentimes third-party payers, it's hospital administrators, it's other people, other entities. So to kind of really pull the lens back and see the legal lane is hugely important, and develop expertise there. But don't be I don't know, I don't want to say it in a really pejorative way, but don't limit your thinking about what you can do. It's more really a question of what you're able to do and where your interests lie. And it's higher value overall to the client.
Great. We have a question in the middle here.
Oh, hi, Paul Roberto. I'm pre-law, so you have to excuse the newbie nature of this question and the ignorance that I have. But what would be the pros and cons of getting a European patent, especially for things like pharmaceuticals that can be easier to go through the process there?
Yeah, I'll kick this off because it comes down to the financial cost of it. And so, as our companies, most of my companies, except for one of them, out of 53, all but one have started in the United States and then expanded globally. And so when you're so young, your company is going to run out of, the biggest risk to having your company fail, your company's going to fail because it runs out of money. So being very smart and very strategic on where to deploy your assets. So the reason, as you expand overseas, the reason not to be so aggressive with your patent portfolio, expanding your patent portfolio overseas, is just due to the cost of it, because you're working with very limited resources. You never have enough time, you never have enough money, you never have enough people, you never have anything. And so how can you be most strategic with that overseas protection? So that's the downside of it. The positive side of it, if you do have that protection overseas, especially in the most critical nations, then you can just setting the pathway to expand over there and to also prohibit competition over there as well.
Yeah, I was thinking that you could, market your product and get some income going in Europe and then move it over to the United States.
Yes, it can, and that would be wonderful. But the resources are so limited that I haven't seen anyone be able to pursue those simultaneously. Most people, it's launching in the United States and then expanding abroad.
clarification. I'm sorry.
Oh, I would just add in, I mean, Europe or any place else in the world, if you're going to go through the PCT process, it is more expensive upfront. You get a little more time to make your final decision. But when you're electing those national stage filings or the EPO or wherever you are, to me, it's a market question. Does it fit with our strategy either to manufacture or sell in those markets, and make sure that we're clear on which of those matter.
Yeah.
You'd never want to check the box on a country for a PCT national stage filing without some confirmation that there was at least a patient population or a business opportunity there. Yeah.
Yeah, so we employ the same kind of philosophy that, we go to PCT, nationalize in countries where we know that market is there, okay, for that particular kind of product. And in some cases, and I can tell you a specific example, which is probably interventional cardiology, which in general, if you look at Japanese markets, okay, invasive cardiology is generally not done. Okay, they generally don't open up the chest. So in intervention, if you have minimally invasive interventional cardiology, invention there will go to Japan to protect the Japanese rights there, because the market is generally very big for interventional cardiology in Japan.
So we do have a few questions online that I want to make sure we get to as well. One was, the law doesn't seem to require having a prototype prior to getting a patent. How valuable do you think it is to have a prototype, whether that's for the purpose of reducing your invention to practice or perhaps for commercialization or licensing?
I think it's a communications tool first and foremost. It's giving I mean, PowerPoint only goes so far. And for Dave or Dr. Heyman to be able to really show, I mean, who we're talking to in industry probably understands the procedure, but to really show why he needs this, he's the voice of the customer here. It moves things along.
I would agree. I think like when we met with the one company, like having the prototype, it really drove home the point of what the design was. And I think it did help take it to the next level for us, just simply in that first initial meeting.
Yeah, and when you're at that stage, you're most likely going to be trying to raise money from angel investors, at least for a venture backable company. And so anything that you can do to increase confidence in you and in what you're doing, anything you can do to minimize the risk will go a long way and try to bring in those first dollars. So yes, I'd say having even a non-working, you mentioned even a non-working prototype, will go a long way in building confidence in the investor base.
Having a prototype, and especially a functional prototype, I think is critically important, not only from a IP standpoint, but from a demonstration standpoint that the technology works, okay, and engaging the right kind of people, either industry or the finance side. I can tell you very recently, we were trying to do market outreach on an invention. We sent a one-page description, pretty well-written one-page description. We don't get it. Then few weeks later, we send a video. They say, now we get it. Okay, let's have a real discussion now. Okay, so it helps.
Great. And when do you feel in the ideation process of trying to come up with the idea that you're eventually going to patent, when should you involve lawyers in that discussion?
Early. And I'm really not saying that as a fee generation plug. We talked about NDAs. I think a lot of inventors don't understand that they could completely vitiate their ability for international protection if they make a public disclosure. And a public disclosure isn't like what we're doing here necessarily. It could just be a conversation in a quiet place in a bar, but there's no expectation of confidentiality. And so a little bit of just rules of the road of trying to maintain as much potential as you can is important. And then obviously, the earlier you can start looking at the prior art, the better you can figure out if there's a way forward. And a lot of inventors do that. A lot of inventors are really skilled at that. But sometimes you just really want to have another set of eyes come back and say, I really don't think there's anything here, or there is.
I think it goes hand in hand with the Ari's question to me earlier about obtaining a mentor. Well, the mentor who's been there can, help facilitate the process, but at the same time, having the legal counsel to know, like, I'm doing everything right. I'm not putting myself at risk or exposure. So, I mean, that was basically as soon as I had my napkin drawing, the next step was go through the legal process.
And I will say a lot of people mess up with, you mentioned the difference between the international and the US systems. A lot of people mess up because they're used to the United States having a grace period that allows the inventor to publish publicly before they file their application, but many international systems don't have that. And so you could be putting yourself at risk to, maybe you can get a US patent, but you won't be able to get those international patents if you do that early disclosure that's allowed under US law. Any other thoughts from folks on?
I'll just go in. Also, it doesn't have to be super expensive. I wouldn't expect a startup to spend $100,000 off the bat. You can find, more cost-effective ways of doing it. And in that clinic, when your, entrepreneurial clinic opens up, that will be a really fantastic resource as well.
Yeah, actually, that's another great pitch, which is if we are able to raise the funding to help open an entrepreneurship clinic for students, that would provide a lot of early stage legal advice on the types of issues like, make sure you're talking to them about getting an NDA, make sure that you're talking to these small inventors about the risks of public disclosure prior to filing your application. And so when you can give that kind of early consult, which can be done by law students under the supervision of a director, that can be great to the community in addition to helping those law students out. Thank you. Any other final thoughts before we close out? Okay, well, I won't keep you guys between here and lunch. Lunch will be out in the lobby and we'll come back at 1 p.m. for the next session on AI.
All right, everybody ready for round two? That's what I like to hear. And the nice part about this panel coming up is that for the attorneys out there, you will get 1.5 hours worth of your attorney professionalism ethics credits, which is always a nice bonus. Good afternoon. I am Ari Sherwin from the Sherwin-Williams Company. I'm not here to sell you paint, although today is a great day to select some colors and do some fall refreshing. We're here to talk about artificial intelligence. And the artificial intelligence market is expected to hit an astounding $300 billion by the end of this year. AI is projected to contribute close to $15 trillion to the global economy by 2030. And within the next decade, supposedly over 150 million new jobs will be added because of IA and AI. We'll get to IA in a second. At the same time, a lot of people are concerned about being displaced or ignored because of AI. And although you may not lose your job to AI, you may be affected by someone who knows how to use AI better than you. So with respect to pros and cons, issues and sub-issues relating to artificial intelligence, we have a power-packed panel of panelists. That came out smoother than I thought it would. And we'll go through some introductions and then just jump right in. We have to my immediate right, Chris Hartrell-Rode, who is a consulting director at Palo Alto Networks. Palo Alto Networks is an American multinational cybersecurity company headquartered in Santa Clara, California, and they offer tons of core platforms relating to firewalls and cloud-based offerings to protect companies, institutions, individuals against cyber attacks and otherwise. And Chris will tell us a little bit more about that in a bit. Palo Alto has customers, organizations, I think in excess of 70,000, encompassing 150 countries throughout the world. And they serve 85 of the Fortune 100 companies. I'm a proud shareholder of Palo Alto Networks, by the way. It is public, exactly. Although, just to disclaim any bias, I do own some stock in CrowdStrike, Fortinet, and Sentinel, although Palo Alto is my favorite. And on that note, Chris is part of Palo Alto Networks Unit 42. So briefly, actually, I'd love to know a little bit about Unit 42 and just a little bit more about yourself before we jump in.
Yeah, absolutely. Thanks, Ari. Hi, everyone. Chris from Unit 42. There's a little bit of background. Our CEO lovingly refers to us as kind of the special forces, boots on the ground unit within Palo Alto Networks. So we're there when there's kind of a bump in the night or a breach. helping clients respond to breaches, and then also proactively defend against them. I'm on the proactive side. So I assist clients with partnering with our ethical hackers. They're hacking within the organization. They find gaps within alerting, log sources. I'm there as the blue team advisor, help them to strengthen security controls. Just as a quick background, started my career in cybersecurity in the military, leading network and security operations centers for NATO communications exercises in Eastern Europe, went to PNC Bank, where I was a SOC lead within their fusion center, and then went on to lead their incident response team. So I'm really excited to work with you here today.
All right, thanks, Chris. And given our current situation with a lot of global hostilities, we really appreciate your service to the country and protecting others around the globe. Sincerely. Also here is Brenna Wasserman, an attorney at Calfee Law. Brenna has an undergraduate degree in physics from the University of Richmond, a master's of science degree in mechanical engineering from Boston University. Tell us a little bit more about yourself.
Yeah, mechanical engineering, not chemical engineering.
Okay.
I'm not going to touch chemicals.
Smart.
But no, so my background is in the sciences. After I graduated, I decided what's one more degree, went back to law school. I'm now a patent attorney, so I've taken the patent bar, and I did patent litigation for a couple of years, and now I'm at Calfee, where I do mostly patent prosecution.
All right, great, thanks. Also with us, Raymond Ling, Associate General Counsel at Progressive Insurance. He's been with the company for close to a quarter of a decade. And you wrote 24 years, so I just rounded it up.
Yeah, that's good.
And he practices in a ton of different areas, including AI law, digital accessibility services for people with disabilities, usage-based insurance, IP with, I think, an emphasis in patents, correct?
Yep.
Well, I'm sure you're dabbling in a lot of
Yes,
areas.
sir.
E-commerce, other technology areas such as autonomous vehicles and open source software. So when you're not practicing law, what are you doing? Any hobbies, interests?
I don't have time for that. Hang out with the new grandpup, which is good.
Congratulations.
Play a little golf, things like that. So,
All right, terrific. Yeah, glad you could be with us today.
thanks.
All right. Also, Nick Froning, he's a partner at Koblenz, Penvose, and Froning from Fargo, North Dakota. I want to hear that North Dakota accent come out at some point. All right. Came to Cleveland about 15 years ago as a proud graduate of Cleveland State College of Law. Thanks for coming back. Right?
Yeah, you got it.
All right, excellent.
Oh, you betcha.
Nice, very nice. And among a lot of different areas, I think you practice mainly with attorney disciplinary
Yeah.
cases, right?
We represent licensed professionals, whether it be doctors, lawyers, nurses, real estate agents. Got to push the button. I'm not allowed to voice. So we represent licensed professionals. A lot of it is ethics and dealing with, I always have a rules of professional conduct book with me. And so I'm the guy that you usually don't want to talk to, or the guy that, Chris may be excited about AI, but I'm going to tell you why you shouldn't.
I like it. And actually, since we have some students in the audience, and I believe close to 100 people listening, viewing online, you also represent law students from time to time, correct?
Yeah, and bar admission matters or character and fitness matters, same with any other profession like nurses that have a checkered past, yeah.
All right, appreciate it. All right, Jess Myers, visiting assistant professor from Akron University School of Law. You have an undergraduate degree in computer science, right? And worked as a software engineer in Northern Virginia. Also had gigs at both Twitter and Google, right? All right, tell us about that.
Great. So I'm Jess. I moved to Ohio from the Silicon Valley, California about a month ago. It's a long story. I used to work for Twitter and then Google, and then I also worked is this not? Is it not? Oh, where? There we go. Is it green?
To hold it for a second.
Now it's not. I swear I'm computer scientist.
Oh, wait. Okay, yeah. Oh, no. Hi, it's green now, I think. Yay.
Right.
Hello. Okay. Anyway, sorry for taking your time. Anyways, and then I worked for Chamber of Progress, which was a tech trade association that worked for, you can think of all the tech companies in Silicon Valley and then some smaller and mid-sized ones. My specialization is in First Amendment, content moderation, and now AI because everybody's doing AI.
All right, great. Thanks, Jess. And finally, Matab Khan, assistant professor here at Cleveland State College of Law. And she teaches, in addition to intellectual property, courses on AI law and other tech-related subjects. I understand that you worked at a few California Bay Area institutions in the past, where you were involved with a lot of legal battles involving digital rights, correct?
Yeah, thank you so much. So I spent time working with Creative Commons, the Wikimedia Foundation, and the EFF, which is the Electronic Frontier Foundation. They all work on the public interest side of technology, law, and policy. And so that's where I began my practice career and went into academia, spent some time at the Yale Information Society project. And now I work primarily on intellectual property and new technologies and how new technologies should be regulated.
All right. Well, thanks for being here. Well, let's jump right into artificial intelligence with Chris Hartrode from Palo Alto. Chris, if you could please take your time and explain to all of us the various methods through which bad actors, threat actors are utilizing AI-driven technologies. And obviously, given your role at Palo Alto, if you can actually even just give us a higher level overview of overall threat landscape that we're all facing, whether corporations, nonprofits, governments, as individuals, you name it.
Yeah, absolutely. I apologize. This will probably be the longest answer I give just because there's a lot to unpack here. But to start at the highest level, there's some trends that are emerging. I think some of them are driven through adoption of AI technologies, right? And when we think about the overall threat landscape, there's really three things to think about. It's scope, speed, and sophistication. When we're talking about scope, I think everybody here that works for even a smaller business knows we're increasingly reliant on third-party software, and there's vulnerabilities, right, with that. And threat actors are doing a really good job through some larger automated campaigns of finding those software vulnerabilities, exploiting them on a large scale before we can patch or even know that something's happened. So for example, we've seen Clop Ransomware Group. They've compromised, I think, over 600 organizations since May of 2023 of last year. We're not really doing ourselves any favors because in 2023, 75% of the cases that Unit 42 worked that had ransomware, they came in through the front door. So they came in through an internet-facing system with the vulnerability essentially out front that was exploited. And when we think about speed, this is the kind of thing that kind of keeps me up at night. Recently had a peer on the forensic side that had a black box, a ransomware case where within 14 hours from a phishing email getting into the network, they had essentially privilege escalated, deployed ransomware, and exfiltrated terabytes of data within 14 hours. The median time that we track at Unit 42 from initial compromise to data exfiltration, in 2021, it was 9 days. In 2023, it's 2 days. Some of the attacks that we're seeing are occurring in hours. So these threat actors are getting a lot quicker moving from that initial compromise, right, that initial vulnerability exploitation into exfiltrating your sensitive data. And then we talk about sophistications where we'll kind of start diving into the AI-driven technologies that are being utilized. We're seeing threat actor groups such as Scattered Spider, Model Libra that aren't necessarily state-sponsored. There's reason to believe that they're based in North America, that they're actually just a bunch of kind of gaming buddies that met on Discord, but they're at the kind of precipice of using social engineering and then also technology to their advantage. So they'll socially engineer the help desk, sometimes utilizing AI-trained, essentially voice mechanisms, right, to masquerade as a member at the firm to reset credentials, reset MFA. They're also sometimes better at using our security tools than we are as defenders. So they'll get in, they'll configure security tools to either not alert or to be configured to be essentially off so that they can move around the environment. We've even seen them use forensics tools to actually find credentials in memory. So just deep diving into the AI-driven portion of that, I apologize again, it's a long answer. There's really 4 ways that they're leveraging AI-driven technologies. I would say number 1 is they're using it for phishing. Everybody in this room has probably had phishing email, scam email, the Nigerian prince scheme, right? You report it to the SOC, they take care of it, it's all good. Anybody that's used AI or ChatGPT knows it's very good at creating comprehensive stories or even checking your grammar. I'm at fault for that, I use it every day. But you're gonna see phishing campaigns, business email compromise that are much more effective, right? Because there's not those signs of missed grammar or misspelling or improper greetings within those. I think the second piece is the automated malware portion. We haven't seen this in the wild yet. There's some research that's troubling. For example, there's been a proof of concept executable where every time it's run, it makes an API call to ChatGPT, where it's creating new forms of malicious code every time it's run. So if anybody's familiar with cybersecurity, a lot of what we do is static detections, right? It's heuristic. It's finding a file that was present before or finding activity that was present before. If we're looking at a new generation of malware, it kind of lowers the bar for entry. We talk about kind of script kiddies lovingly in the cybersecurity realm. It's somebody that doesn't have a lot of experience that can hack a company, right? I think we're going to see a lot more activity there. I think there's a whole brand new attack vector for your company as well. If you're leveraging AI, right, you want it to interact with your customer data or you want it to interact with your customers. So there's a whole new, essentially, threat vector. And then finally, I think this is probably something we're definitely going to talk about is impersonation. So threat actors are utilizing that to socially engineer, masquerade as certain personnel. They're also utilizing it to essentially put out spam campaigns or scam campaigns, right? They have AI videos of Elon Musk or Tucker Carlson that are selling some kind of software, some kind of new cryptocurrency. Users are entering in information and they're depositing money. They're not being able to get it back. I think overall, it's not going to be a question of if AI is adopted by threat actors, it's just how fast. I think overall what we're seeing is they're adapting pretty quickly to it.
All right, great. Thanks, Chris. And I got to tell you, every time I see Unit 42, the division you work in, I can't help about thinking about Area 51. So just curious if any of that AI technology is alien driven. All right, let's swing to the other end of the pendulum with Brenna in terms of getting some legal perspective on issues related to humans taking credit for AI work.
Yeah, I mean, speaking of bad actors, I mean, for me, the first thing that I think of when people bring up AI and ethics in the same sentence is basically using AI models to cheat. So we've seen this in multiple places already. I'm sure Nick is going to talk more about this. But we're at a university right now. Students have been caught using ChatGPT to write their college admissions essays. Lawyers have been caught using ChatGPT to write their briefs. It's one of the upcoming problems in a space where as AI kind of gets smarter and gets better at writing this kind of stuff, it becomes a lot harder for us to catch it. Because as we get better at recognizing, oh, this was written by AI or this was written by a program, the programs are, you know, as Chris was talking about, they're constantly iterating and they're becoming better and better and better, and they're becoming better and better at hiding it. In a copyright space, and we'll again talk probably more about this later, people are using AI to generate images and artworks, and the AI has been created by scraping that artwork from artists without their consent. So there's a lot of companies right now. So like if on YouTube or Instagram, you'll see, you know, you have to check a box that says like this content wasn't generated with AI, or there was some amount of AI that was used in this particular thing. In the copyright area specifically, the Copyright Office has now taken a stand and said you have to disclose if your particular artwork or piece of art was created using AI. And you have to sort of disclose, you know, what that assistance was, how much the AI helped. So I think, again, as those programs get better, it's going to be interesting, to say the least, how we work to kind of regulate that whole area in that industry.
All right, thanks.
And the patent office and the copyright office won't accept AI generated works, correct?
That's correct. You know, it's a little spoiler for later, Ray.
Sorry. Sorry for getting ahead.
That's okay. But yes, that's true. They've gone on record and said that if you say that an AI created this entire thing, we're just not going to accept it. We only do humans.
Ray, we'll continue with you. Ray Lang from Progressive Insurance. Just given the rapid pace of AI innovation, how should companies ensure long-term compliance with AI-related laws and regulations, especially as they evolve?
Well, I think there's a few ways to answer that. So one of the things that we're seeing at Progressive is we work with a lot of vendors, a lot of external vendors provide products and services to us. And what we're seeing now is we're starting to argue about whose laws apply or to which company in terms of delivering services that are include or infused with artificial intelligence. So, typically say, oh, we'll apply to or we'll comply with applicable law. Well, applicable to who? We're an insurance company and we're highly regulated, as you all know, at the state level. We're seeing a lot more than perhaps a lot of other folks in terms of AI regulation. So when you work with us, it really is helpful if as that vendor that you have some understanding of what it is that we're having to deal with in the laws that we have to comply with, as well as the things that you might have to do that you're seeing at the federal or state level. But I think from our standpoint, it's really important to have a good relationship between legal and IT and your data science folks, the folks who are doing the model development and deployment and so forth. As in-house counsel, it's incumbent upon us to make sure that our folks know what the rules of the road are and what we anticipate will be. And so it's important for us to convey that and have an understanding with those folks who are have the boots on the ground who are working in those areas. I think it's also important for us, again, as an insurance company, but I think most any company doing business, is to understand the sensitivities and the concerns that people have with regard to AI. So it's important to us because it's a breakthrough technology. It's one of those overnight successes that's been around for decades, but it's still a breakthrough in the last 2 years since OpenAI, unveiled ChatGPT. And there are sensitivities. We heard a little bit earlier about people concerned about their jobs and so forth, but also kind of that black box approach to working with me as a consumer of your product or your service. And so understand that people are going to have some of those concerns and kind of be aware of that as you're going through this process. Internally, it's important for us, and I think for other companies, to be thinking about making sure that AI issues are incorporated into your internal risk management approach. I think it's also important to have an AI governance structure of some sort, whatever works for your company, to make sure that, among other things, you've got visibility at the highest reaches of the company into the models that you're deploying, understanding what those models are, what the inputs and outputs are, and that you're monitoring those models for drift and bias, for discrimination, those kinds of things. Now, we as an insurance company, we're in the business of discriminating based on risk, not based on protected class, but based on risk. And we have to make sure that we are focused on what the risk presents and not take other characteristics into account. So that's what is incumbent upon us to make sure that we are doing. I don't know if anybody else has anything to add to that laundry list.
I'm curious if there's a particular country or space that you kind of look to set the bar for future regulations related to AI.
Unfortunately, I'm with Progressive and not State Farm, and so we only do business here. So we focus here, but you raise a good question in terms of trying to anticipate what may be coming down the pike. So a few years ago, with GDPR, from a privacy perspective, we wanted to understand GDPR, even though we don't do business in the European Union. We had a sense that, hey, it's going to be imported to the US. And in some ways it was through CCPA. The EU recently adopted its AI Act, and I don't know if that will be adopted wholesale here in the US, but I think it's it's an opportunity to learn a little bit more and see how that is going to be implemented and enforced and so forth. So there are things that we can learn, but because we only operate domestically, at least at this point, we're focused on obviously at the federal level, although there's a lot of talk and not a ton of action. And at the state level, there's a lot of activity for us because that's where we are primarily regulated.
Makes your job easier, I guess, with respect to your iconic spokesperson flow. You don't have to do any enforcement of
Flow,
foreign
yeah.
flows
Yeah.
outside of the US.
Well, we got AI flow. We have, yeah.
Yes. All right. So Nick, enlighten us. We need some CLE accreditation perspective here. If you could provide some just general guidelines in terms of best policies, procedures for utilizing AI ethically, whether you want to reference specific rules in the Ohio Code of Professional Responsibility, feel free to talk about fee, arrangement, acknowledgement. Go for it.
Great. So first off, I become terrified when Chris gets up and gives his answer and talks about all these threat actors and all these situations where individuals could infiltrate our systems. I was talking to Chris before this, and just so we're very clear, I'm really good with the rules of professional conduct. AI and cybersecurity is not one of our firm's strong suits, and so I told Chris earlier that our mechanism to stop cyber attacks is that Richard Koblenz from the firm is not connected to a server, because he will click on anything in an email and that computer will be shut down, and so he has no access. And so that's where we kind of draw the line. I'm very interested in AI and getting involved, but I carry this book, this rules of professional conduct, with me at any time. And even though AI and this technology is moving light years, is moving so fast, our rules of professional conduct are very slow to modernize, and so we're stuck reviewing rules and interpreting rules subjectively in how they apply to us as lawyers. And before we started this panel, and I put this very big at the top of my notes, this is the best disclaimer I can give you. Robot lawyers do not have disciplinary hearings. Real lawyers do, right? And so anytime you're using AI, the lawyer is responsible for the content provided, right? And we can talk about that in rules 5.1 and 5.3 that deal with supervising lawyers or non-lawyers or third parties or outside counsel and outside counsel agreements if you're a company. And you asked me for general guidance. General guidance is this, right? I think anytime for a corporation that they're using outside counsel, they should have some sort of AI provision in an outside counsel agreement, ensuring that their outside counsel is complying with whatever policy that the company has. If you're a law firm, I think that at a very minimum, if you utilize AI, there has to be a provision in your fee agreement that talks about the use of AI. And that would satisfy your obligations under 1.4, which is communication and keeping our client reasonably informed as to the means that we accomplish their objectives. Now, that's not enough to satisfy your obligations under 1.6, which is, I should be quizzing the law students in here really when I say these rules. I cite them off because I know them, but I should be asking you what these rules are, right? And you can tell me. But confidentiality, right? If we're going to use confidentiality, you have to give your clients, you have to get informed consent. And what is informed consent? Well, it isn't just a boilerplate provision in your fee agreement. It's actually having a dialogue with your client about the risks, about the benefits, about the what this is going to do, where this information could go. And so, maybe my guidance is that there's a fee. If you're a law firm, it's a fee agreement provision that is probably fairly long, which lawyers hate when I say you should have a long fee agreement, because they always want these short fee agreements for whatever reason, because they say their clients like them. And I get upset because the contract that you signed for your cell phone or your TV subscription or whatever, where to log into ChatGPT is longer than that of a legal professional contract, right? I have a real problem with that. But your fee agreement should have this, this section, and the client may have to acknowledge it right in the fee agreement itself. Have them sign right in the fee agreement in a special place that talks about AI and them giving their informed disclosure. And so I think, and then you get into, you talk to Chris or Ray or Jess about whether or not you should be even using an open source AI, or whether you should be purchasing a license to a closed source AI. Now, the only reason I know the difference between this is because I was just back from my high school reunion, and on the way back to Cleveland last week, I sat with a Microsoft exec, and he was telling me about the difference between these systems. And so that's where I got that knowledge, because I'm clearly incompetent when it comes to AI and its advancement, but there are surely a lot of ethical issues.
All right, thanks. So we'll pick up with respect to some of those other rules in just a little bit. Thank you. All right, let's go back to Chris from Palo Alto. How can companies, schools, organizations, individuals specifically better protect themselves from attacks involving AI technology? And let's go down some rabbit holes involving social engineering, deep fakes. Would love to hear your take.
Yeah, absolutely. I think to Nick's point, it's something that we're seeing across organizations. So every client that I work with is trying to wrap their head around, how do I mitigate risk associated with AI? And I would say there's not a lot of frameworks right now, particularly in the cybersecurity realm, to kind of start framing that discussion. But if I was going to look at mitigating risk, I would separate it into three categories. Number one is, how do I mitigate risk associated with threat actors utilizing AI-driven technology? So how do I mitigate against social engineering, right? Deep fakes, things of that nature. Number two is, how do I prepare my own internal systems that are utilizing AI and harden them from exploits? So like we talked about at the beginning, if you're starting to leverage machine learning, AI within your organization, that's a whole new threat vector for threat actors to essentially come into your network. Number one, they can use prompt engineering to essentially manipulate the things that they're asking your model to get it to do something that you don't want it to do. Number two, they can essentially use data poisoning to poison the training data that your model is using to make predictions, to again, make it do things that you don't want to do. I think the third most interesting point that they can utilize is they can find data that's living within the unstructured data in your LLM that might have been put there by mistake. So a lot of users are utilizing ChatGPT, are utilizing a lot of these open source solutions. Maybe they're plugging in sensitive information, proprietary information without knowing, and it's sitting there somewhere in that model. And I think the third portion is exactly that note, right? How do you prevent your users from leaking that data accidentally? I think just tactically, from what we've seen from some of the bigger breaches that have involved some of this activity or these platforms, I think the one area to focus in on right now is your service desk. So there's been a lot of high profile breaches that started with the service desk, that started with the threat actor calling in, masquerading, utilizing deep fakes to masquerade as another user to get actions on objective, reset user credentials, reset MFA. We also had a case where $25 million was transferred out of the firm from an impersonation of the CFO utilizing a deep fake video. I think that's number one. Number two is making sure that you have a clear escalation path from your service desk up to your security operations center. I find it amazing. I work with a lot of clients, and it's either I kind of get looked like I'm crazy or deer in the headlights look when we ask about, okay, if there is a social engineering campaign, how does your service desk even know about it? How do they escalate it up to your security team? And what are they providing? The other thing to note there too is to test it, right? There's a lot of firms out there that will do social engineering testing. Have them test your service desk, the validations that it takes to reset credentials, especially for your executive staff, for your IT staff. I think finally, the thing I want to advocate for the most is this is definitely not the time to tighten the belt on the security data that you're sending over to your blue team or your security operations team. I come from that background. I'm always going to advocate for it. But the way that we're going to win an AI arms race against these threat actors is with data. We need to beat compute with compute. So I would figure out ways and review ways that you're sending your data to your SOC so that if you get an alert at 2 a.m. or there's a bump in the night, they're not waiting to call somebody until the morning. Because like we talked about before, it takes about hours now for threat actors to go from initial compromise through terabytes of data being extracted.
Great. No, thank you very much, Chris. And actually, staying on the topic of deep fakes, and I don't have the footnoted specific source, but I can find it if need be. It's been estimated that over 95% of the largest use of deepfakes online relates to non-consensual pornography, which is a huge issue. And previously, one way to address non-consensual pornography was through copyright law. So I'm curious, Jess, is IP still available to solve this problem with this type of use of deepfakes? And what else is needed in this area?
And before we jump into this question, I just want to take a moment because I feel like we've been talking a lot about how scary AI is, and I want to give sort of the opposite perspective. I love AI. I was an early adopter of ChatGPT. I used AI in my policy practice. I encourage my law students, my first year students, to use it. They're using it right now to generate torts hypos so that they can practice. I think it's a field leveler. I think it's a really important game changer, and I think it's groundbreaking technology. And to the students in this room, it's not going away. You need to learn how to use this technology. You need to be competent with it. You need to know the limits, right? So you shouldn't be afraid of it. I see it as just like the next great invention on top of the internet. So yes, these are really important and valid points that are coming from my co-panelists, but also I embrace the technology. I think it's exciting. Now, with that said, let's talk about non-consensual pornography. So first of all, non-consensual exploitative imagery. It's not pornography because folks cannot consent. I want to unpack this a little bit, right? So you have non-consensual exploitative imagery. You have what you might see as like face swap or Photoshop, where you're taking somebody's actual face and maybe putting it onto an existing photo. And then you have deep fakes, and deep fakes are getting into machine learning generated images that use deep learning and a lot of the data synthesis and training that we've been talking about to create artificial images. And the law, it matters that we separate these because the law kind of differs between each of these categories. When I say non-consensual exploitative imagery, and you mentioned about how copyright was a good tool for that, that's because we're talking about real images, usually images that have been taken without the consent of another individual. And that individual, depending on if it's their photos, if you've sent somebody an explicit image, you have ownership in that photo, and that's where copyright can come in as an important tool for you to use. But it differs when we're talking about the different types of images. Deepfakes are not new to AI. This is not a unique, phenomenon to AI. We've had deepfakes before. It's just that the current tools that we have been seeing with AI might empower its faster production. So what do we have that's available to us to protect our clients and individuals who are victims of deepfakes and other types of, photo swap and non-consensual imagery? Well, we have IP. That's a first start, right? So in the US, it's a little bit difficult because when we're talking about deepfakes, we can't not talk about the First Amendment implications that arise. One really good example is, unfortunately, the example from Elon Musk, who recently tweeted that deepfake image of Kamala Harris's, I think, rally, and Governor Newsom came in and had said, well, California just banned deepfakes, and so we just made that illegal. And you might be thinking, well, that sounds progressive, right? But at the same time, it's kind of a dangerous and concerning notion to see the government come in and sort of chastise folks for doing parody, things that we've had all this time, regardless of the technology that's being used. That aside, copyright is still in play when we're talking about non-consensual exploitative imagery. If we're talking about images that you've taken, that we're not talking about deepfake, we're not really even talking about face swap, you might be able to bring a copyright claim to say that you own that photo and the person who's using it is using it inappropriately, not as fair use. You might also be able to do that for the face swap situation. Again, if somebody's taken your photo and they're using that photo, you might have expressive elements or ownership over those elements of that photo that you might have a copyright claim to. Deepfakes get a little bit trickier because you may not own there might not be a part of the image that you actually own. It might be this conglomerate output of data that was used to train the model to then get to that output, but you're not hosed yet. Right now, we've got the courts still considering what to do about fair use when it comes to AI training. We're still waiting for that result to take place. It's my opinion that I think there's a big difference between ChatGPT and that uses their models to take on tons and tons of data to get to an output that might be, a representation of all sorts of different information that's been collected. And take, for example, something like Taylor Swift GPT, where you've taken your model is entirely trained on Taylor Swift's works, Taylor Swift's photos, to then produce really awful non-consensual imagery of Taylor Swift. A court may not find that to be fair use. And the last thing to keep in mind too is right of publicity laws. So right of publicity, we don't have a federal right of publicity law. We have 50 different varying state right of publicity laws. Right of publicity says that and for commercial contexts and for other contexts, folks cannot use your name, likeness, face, et cetera, for commercial and otherwise other purposes that you haven't consented to. And again, it depends on the state. Tennessee just enacted the Elvis Act, which adds voice to Tennessee's Right of Publicity Act, existing right of publicity law, which means that voice replicas might be at issue, at least in the state of Tennessee. So when you ask what might be needed, well, for starters, maybe a federal privacy law that embeds a lot of these differing 50 state right of publicity principles so that we have federal preemption that we might be able to use to address deepfake situations. But all of this is to say, we need to keep in mind that we have to do this carefully when we're talking about regulating AI, because a lot of this is about regulating expressive outputs and expressive elements that we don't want to get into infringing the First Amendment. And the last point I'll make for all of you in the room here, digital and media literacy is going to be really important for all of us. That's why I keep telling students, please learn how these products work. Limit your exposure to what's online. The more information and data you're putting on the internet, on social media, the more these companies are able to scrape and use these images and potentially use them against you. So it's important to understand how this technology works so that you can better protect yourself and your clients.
Thanks, Jess. And I appreciate you bringing up the fact that there are plenty of positive uses of AI. Maybe I'm too cynical because I've been practicing for too long and focus on some of the hypersensitive areas, but thanks again for addressing that and terrific points. So let's go back to you, Nick. Sprinkle in some more Ohio, or not just even Ohio, but just general rules of professional conduct. Get us some more CLE credit here.
Yeah, I like that we talk about the benefits for just 30 seconds, and then we go back to just these things that are
positive.
I wrote on my thing here from Chris's last talk. Trust no one, right? It sounds like I should trust no one. I don't.
Principle.
Everybody's trying to get into my computer system. These are the, but to off of Jess a little bit, right? We're talking about First Amendment, and I think it's important as lawyers in the state of Ohio, we do not have unfettered First Amendment rights, right? We can't just go say or produce or print anything that we want to print. We have the obligations to the profession and the administration of justice. Now, if you follow Supreme Court decisions and some of the disciplinary matters, we've seen that over the last year or two, we kind of see that some of the justices in our Ohio Supreme Court are questioning the limitations on lawyers' First Amendment rights. But as we sit here today, right, we don't have just the ability to say or do whatever we want because we are lawyers 24/7. And so I think that's important. And in terms of this, as Jess is talking about these deep fakes and all this other stuff, I'm thinking to myself, I'm waiting for the first lawyer to create some images, some advertising images to promote their firm because they were handshaking with Taylor Swift, and how that, Taylor Swift trusts me, so you should too, right? Now, and we weren't going to get into that today, but the rules would clearly cover that imagery or that usage would be false, misleading, and or non-verifiable under the advertising rules contained in 7.1, 7.2, and 7.3. Kind of back to this confidentiality, and I think there's always a misunderstanding of in our profession of confidentiality versus attorney-client privilege. And I want to be very clear. Confidentiality is much broader than attorney-client privilege. It is that we have to keep anything and everything confidential regardless of its source. Whether or not Chris knows that I represent somebody or don't represent somebody, I can't confirm, deny, or otherwise, right? I can't tell him, even if it was on the news yesterday, right? It's still confidential information that I can't disclose. As it comes to AI and this confidentiality, we talked about how important it is to have our clients, if we are going to use it, that they give us informed consent. But that's not in every case. We don't always need informed consent. If we're using Chat GPT or whatever AI platform you want to use, and we're using it for idea generation or something like how will this judge rule on a certain issue, right? We're not putting necessarily client confidential information into that system. I think I thought about this when I attended here in 2010 to 2013, we had a professor by the name of Michael Harvey, and Michael Harvey taught legal writing and litigation. And he used to just really just walk up and down the classroom talking about CYA, cover your and everything in writing. And I think that's applicable not only in our fee agreements, but also in our writings so that our clients are well informed and so that there's no surprises. And that's all proactive. Anything I tell you today is really proactive and it's good and you should listen and you should do it because I'm really expensive to hire when you have a problem and we have to defend against something. And so this is why you should listen.
All right, thanks, Nick. And kind of to get back to some of the positives too, let's go back to you, Brenna, in terms of not problems associated, but what are some of the issues associated with protecting end products developed either by or with the aid of generative AI, and maybe even touch upon some public disclosure areas that could be affected as well. I'd appreciate it.
Yeah, of course. So as Ray mentioned earlier, thanks, Ray. The U.S. Patent Office and the Copyright Office have kind of gone, and the Trademark Office as well, have kind of gone on the record and said, look, we're only doing stuff that was created by humans. We are not doing anything that was created by AI. So a couple of years ago, there was a case that was called like the Davis decision, where a person said, okay, basically, I am not the inventor of this particular invention, but in fact, the AI created it, and I don't know how it works, but the AI does. So you should give them the patent. And the Patent Office said, no, we're not doing that. It's ridiculous. And he appealed and appealed. And basically what we've decided at this point, and Congress has agreed that only humans can be inventors, only humans can hold patents, only humans can hold copyright, and only humans can hold trademarks. There is like some precedence for this. There was a photo that was relatively famous like a few years ago where a monkey took a selfie. And the photographer who handed the monkey the camera said, oh, I own the copyright on this photo. And basically it was determined that he did not own the copyright on this photo. Only humans can own copyrights. The monkey was not able to own the copyright either. So, right now we've just made that decision. It's just it's a black and white line. You know, did a human create this? Yes or no? But I think as AI becomes more generative, I think it's going to turn into something more like a threshold requirement. So right now, there are these AI art bots, and you can put in these incredibly, incredibly specific prompts, and it will create incredibly detailed artwork. And there is there's, you know, of course, the other half of this is the fair use argument on, okay, where did it get all of that information to create that artwork? But for the time being, we'll stick to this side. And so you have ostensibly created that artwork because you are the one who provided that AI with that particular prompt. So how much actually did you have, how much control did you actually have over that artwork? You know, can you copyright that? How much input did you have on that particular thing? I think as AI becomes more generative, I'm interested to see how much it generates. So I have 2 children. They're very small. They cannot talk yet. But let's say, for example, there's some sort of AI art prompt that works based off of speech. So they go up to it and they say like dragons or cars, and it creates this beautiful image that's a beautiful piece of artwork that has, dragons and cars, and oh my gosh, it's beautiful. Could my 14-month-old daughter get a copyright on that picture that she created? Probably not. And that's probably for the best. But it does kind of become a greater discussion on what is the inherent protection of artwork. We have the Copyright Office because we believe that artwork is worth protecting. But I think we're going to have to come to we're going to have to reconcile at some point, when does artwork become inherently worth protecting? Or is it only worth protecting if it's generated by a human? And then on the more technical side of things, I do think we are going to eventually run into a problem where somebody uses an AI model to create something and they genuinely do not know how it works and they're not sure how to reproduce it. But the AI model can reproduce it pretty consistently. So is that something that now just belongs to the public because it cannot be patented? I think that as that kind of continues, it's going to be an interesting space. And then if I can keep talking about public
Great. No,
disclosure.
we'll get back to you. Thank you very much, Brenna. All right. In addition to use, Ray, I'd love your input in terms of how companies and others can help mitigate risk associated with not just developing, but deploying AI technologies, especially in highly regulated industries and sectors like insurance.
Sure. So we talked a little bit earlier about kind of understanding the rules that you're working under. And I think that's going to continue to be important. Not just the specific laws and regulations, but even governmental pronouncements, also best practices. So NIST, which is part of the Department of Commerce, put out an AI risk management framework. It's very lengthy, but there's some good nuggets in there. The Biden administration's executive order from last year, there's some good nuggets in there. Doesn't apply directly to us, but it gives you a sense of where the government may be. And so those are the kinds of things that we want to make sure that we understand and again, kind of convey internally. We talked a little bit earlier also about understanding your model inputs and outputs. So what data are you feeding in? And I like the comment earlier about using or thinking about using closed source large language models or other generative AI sources to protect. And I think Chris is going to get into this later about data leakage, so I'll leave that to him. Instituting controls. There's a vendor that can do most anything for you, and there's a vendor that'll do that too. And we're using one, and we've looked at a couple of others, but because of the regulations that we've seen imposed on us, we use those nuggets to pick out certain controls that we think we ought to implement as part of our monitoring process. And this is probably something that Chris could get into much more in a learned way than I can, but red teaming is something that we've talked about. It's a concept from cybersecurity, but I think it's also being applied now to AI, where you can kind of have somebody else test to see if they can exploit any potential vulnerabilities in the way that you are using AI and be able to relate that back to your teams so they can try to prevent those issues going forward. So there's any number of things that you can do and actually should do. I would echo what Jess said in terms of the positives for AI. There are a whole lot of them out there, efficiencies and the ability to do mundane tasks and repeatable tasks. So you free people up to do more important work. Those are all really good things. And what we've tried to do is make sure that, hey guys, have at it, test it responsibly. And we talk about our program as being responsible AI. Some people refer to it as ethical AI. But the idea is that we don't want to hamper your ability to do experiments and to think about different ways that we can take this technology and really make a great use of it. Hopefully bring down prices, whatever it may be, but do so in a responsible way and in a manner that we can be able to explain to regulators and say, look, here's the program we put into place. Here are the people that are involved. We've got a disciplinarily diverse group of people. We've got people from across the organization who are responsible for different things, including legal, but not limited to legal. And in that way, I think you're going to have the appropriate level of checks and balances and an ability to explain what you're doing to others in a manner that makes them feel comfortable with what you're doing going forward.
Thanks, Ray. Actually, piggybacking those comments, Jess, I'd love to hear your thoughts in terms of like what role platform liability has to play in addressing the risk of deepfakes.
Yes, and I also think Ray's point about how AI is going to, make things more efficient, change the way that we do our jobs. I thought that was really, really important. I wanted to kind of double click on that really quick, especially when we're talking about us as lawyers and where our jobs are going to be when it comes to AI. I really do think it's not going to be a case of like AI is going to replace us. To Nick's point, robot lawyers are not the ones that get to go to the hearings. It's us, of course. But I think it's going to change the way that we do legal practice and the way that we, I think it's going to free us up for being able to be more problem solvers and design architects rather than, just also doing some of the text generation and writing that we typically do as lawyers. So to the students in the room, again, I'm excited about AI. I'm not worried about our jobs yet. So about platform liability. So yeah, we'll see next year when we get the singularity. All right. So about platform liability, right? I want to bucket two things here. You have the social media services, for example, like Meta, Twitter, YouTube, that are hosts of deepfake content, other types of content, third-party content. And then you have the platforms like ChatGPT, for example, that folks are using to generate the perhaps deepfake or other types of content that might be at issue here. And it's really important that we talk about these separately. Again, different legal issues, right? So the baseline in the United States, I'm only going to talk about the US. Baseline in the United States, internet companies have a First Amendment right to host third-party speech. Okay, there's a couple limits on that, but recent Supreme Court case, Net Choice v. Moody and Paxton, the Supreme Court, then and back in ACLU v. Reno, long time ago in the 90s, basically made that point. Internet services have editorial rights to host content. So that's our baseline. And again, that's why this makes it very difficult when we're talking about folks uploading deepfake technology to platforms in the US. Well, these services have a right to decide whether they want to carry that content or not. Going a layer above that, we have something called Section 230 in the United States. And Section 230 says that websites are not liable for third-party content. Similar to the First Amendment, but it adds a layer of protection so that these issues, when they come into court, we don't have to have a First Amendment discussion. We can end this on a motion to dismiss. Websites are not liable for the third-party content that's uploaded to their services. There are questions right now about whether Section 230 applies to services like ChatGPT. Is it third-party content, for example, if I am asking ChatGPT to make me a deepfake of Taylor Swift, for example? Whose content is it? That is still an open question. I have my thoughts on it. We don't have to go down that road, but that's why we're saying we're keeping it separate. But at least for now, again, deepfakes are not new. We were dealing with deepfakes on Twitter back into the 2016 election with the Russians putting out, fake imagery and fake issues and whatnot to try to fool the United States voters, right? First Amendment still applies. Section 230 still applies. Now, there's some exceptions. We talked about IP last time I was discussing this. Section 230 has a federal intellectual property exemption for federal copyright. When we're talking about right of publicity, it gets a little wonky because we only have state right of publicity. In the Ninth Circuit, Section 230 protects, immunizes claims with regards to right of publicity. In the Third Circuit and outside the Ninth Circuit, it's anybody's game. We don't know. The Third Circuit says that Section 230 doesn't apply. Sixth Circuit's had some wonky opinions. So again, this is why I've been kind of talking about, well, we have to really make a decision about what the right of publicity is. Is it an intellectual property law? Do we want federal preemption, et cetera? So we have our copyright and our IP exemptions under those laws. And again, when we're looking at things like the social media services, you all might be familiar with something called the DMCA. Section 512 of the DMCA says that social media services, once they're on notice that somebody has uploaded information that violates somebody else's copyright, they need to take it down. So it's very different from the protection they automatically get from Section 230. So you can think about, okay, someone uploads non-consensual exploitative imagery. Maybe it's a deep fake, maybe it's the face swap situation. Maybe this is where DMCA kind of takes the role where you can put in a notice to these companies to take this stuff down. And then the last thing to think about under the legal liability for these companies is the federal criminal law exemption to Section 230 as well. And so for some items, some information, some speech is illegal. Child sexual abuse material is illegal. Though asterisk, virtual child sexual abuse material is kind of undecided under the First Amendment, which feels really icky, right? And again, we're talking about deep fakes. So deep fake child sexual abuse material, kind of unclear. Anything else? Violation of federal criminal law, platforms must take it down. But it's not just the legal liabilities that we have to think about as well. There's also policy reasons why these companies take content down. The mainstream internet services, they remove deep fakes and misinformation and disinformation because it's bad for their users, it's bad for their advertisers. Emphasis on the latter. It's really bad for the advertisers. Look at what happened to Twitter when Elon Musk refused to take anything down. The advertisers left. And then the last thing I'll leave you with is that there's also some really interesting content moderation complexities that come up with deepfakes. What happens when there are real images coming out from some of these other countries, some of the conflicts that we're seeing around the world, and folks are claiming that those are deepfakes? There's current initiatives, private initiatives right now, like Adobe's C2PA initiative, that is working to help identify whether something is a deep fake. But you can imagine the kind of situation these companies are in when they're making decisions about taking down information that could be really important for the public to know, see, and have access to. So that's kind of the platform liability in a nutshell for both.
That's a lot to digest, and that's not coffee. She's drinking water. Thanks, Jess. That's terrific. That's awesome. No, great points. Now we're about 2/3 of the way through already. Should we take 30 seconds to do that polling question? And then we'll go another 20 minutes or so and do some Q&A. I'd love to get Matab up here as well to get your perspective. Scraping's been mentioned, so sound good?
Here we go. Let's launch the poll online. And then we also have an online question that related to one of the topics that was just discussed, which was directed for Nick. Do you recommend that fee agreements have a certain level of detail as to what types of services, if folks are sort of incidentally researching topics using AI, to what extent should they disclose that their associates might be doing that kind of incidental research?
Well, yes, and I think we covered it slightly, right? I think the fee, to me, a fee agreement should be reviewed and edited and changed almost on a yearly basis because things come up or advisory opinions come out or cases come out, and it is it's a contract. It is a contract between us and our clients. And so I think that the more that's in there, it tells us what I'm going to do. It tells us what my client is going to do. It tells us what to do in certain circumstances. I look at fee agreements or contracts in any sense as rules to our relationship, right? If our relationship's fantastic, nobody ever has to look at it, right? But if in terms of a fee agreement, yeah, I absolutely think there should be not just a boilerplate provision, but a substantive discussion about the client has been told of the risks and the benefits. Check here, initial here. The client has been advised of what information may be used. Check this box, initial here, right? It's almost like, the only thing I can think of is the lead disclosure requirements when you're selling a house, right? I think it's almost check the box and move on. And so, yeah, I think the fee agreement should absolutely cover this among a whole host of other provisions.
Great, thanks.
And before you ask it, because I think I'm up next anyway, but we not to be a killer of efficiencies here, but Ray said efficient, this is efficient, and Jess said this is efficient, and I think it will be efficient, but it will be efficient at a cost to a series of lawyers. We've developed kind of this model, this fee model over decades, and this efficiency is going to clearly cut into the costs and fees that lawyers can charge, right? And so if you're on an hourly representation and you use AI and all of a sudden it used to take you 30 minutes to prepare some sort of template document and now it only takes you 6, you can only charge for 6. Same thing in terms if you represent on a flat fee representation. If it used to be, I don't know, let's say $5,000 for a copyright application, and now you can do it with AI and it only takes an hour, right? Even though it's a flat fee, the fee still has to be reasonable. And so now you've put in much less time to do the work that you historically did. And so it might be an unreasonable fee, and fees for lawyers have been created based upon our investment into our education, the cost of our education and what we have to pay back for it, the overhead associated with running a law practice. I mean, there's really only a finite amount of clients and legal problems that exist, right? Unless you can, if you're law students, I guess maybe that's my disclaimer to law students, right? Find a niche, right? Find a legal problem caused by AI and get into that, right? Because, I'm sorry to tell you, it will never be a field that I'll be in, right? I'm just not going to do it. And so I'm going to stay in my lane. You should find where the next set of legal problems exist, right? And that's where you're going to be able to make money because, if I implement AI and I only have a finite amount of clients, we're going to have, decreasing profits. And that's where the efficiency is. The risk of that efficiency, right,
And increased available access to legal resources, though. On the flip side, more people get access to the law.
Sure. I agree with
barriers.
I agree with that, but I think my favorite then is when clients utilize ChatGPT to tell me what the law is and how to do my job, right? And so we get a whole sect of keyboard lawyers, right? And then they make our jobs more difficult.
All right, on that note, let's go back to massive scraping of data. And I'd like to get Mehtab Khan up here, assistant professor here at Cleveland State, teaches various topics related to AI. And we'll just touch upon some copyright infringement issues relating to AI training models. I was back in December 2023, lawsuit filed by New York Times against Microsoft and OpenAI for copy infringement. The defendants allegedly using the New York Times material so that Microsoft and OpenAI can build their models based upon that information that now directly compete with the New York Times. So I would love your insight on that, Mehtab. Thank you.
Thank you so much, Shari. I think Jess covered this topic well. You summarized it, and generally, abstract training of AI models might be seen as transformative enough to count as fair use, but the more specific ones that allow you to infringe upon someone's works or their likeness, like if you created a Taylor Swift GPT or a Drake GPT, maybe that's not fair use. But within this discussion, you can debate back and forth about what is and isn't fair use. But what I would like to draw your attention to is the risk that we have here is that we risk creating an AI privilege against humans when it comes to learning. And I say this because one, when you dig a little bit deeper into the sources that are being used, some of these sources are what are known as shadow libraries, which are books and repositories uploaded to the internet, copied without authorization that people who cannot afford books use to download and then and learn from. And one of the arguments that we see coming up to consider AI training as fair use is that models are just learning the abstract features of these works, and they're not taking in the expressive parts of it that are protected by copyright. But human beings are also learning, and they're also not taking the expressive parts and also replicating them or reproducing them or distributing them without authorization. So there's a risk here that we might create an AI privilege against humans. And the second aspect of it is that there is case law that has held that just even personal use, where you are taking works to learn in a personal capacity, might not be fair, especially if a licensing market exists. So it'll be interesting to see how these arguments play out when AI models or AI agents are doing what human beings on a much smaller scale might not be allowed to do. Having said that, I think that we've discussed a whole range of different practice areas that are impacted. We've talked about different systems. What I'm hearing our panelists talk about are outcome and decision-making systems. We've heard about predictive systems. We've heard about generative systems. All of these systems, I think, will require their own responses when it comes to regulation. So I would love to hear from the panelists also about what they think or who they think are important stakeholders, institutions that have to be involved or more involved in the regulatory landscape that they are specifically dealing with, and what would they like to see come within the scope of the law or outside the scope of the law as far as they are seeing in their practice areas. Anybody?
I do have thoughts. I have a lot of thoughts on this. It's a great question. I have a lot of thoughts. So I just, before I became a law professor, the last thing that I did at Chamber of Progress was campaign to fight SB 1047 in California, which was a bill to ensure that it was going to hamstring security efforts around security teams for AI. It was going to say that you couldn't start training or even developing models unless it got approved by California's AI DMV. And what the bill didn't do, and the bill sponsors didn't do, was they didn't talk to engineers. They didn't talk to folks like Chris, who have experience in cybersecurity, who understand why we need to be able to empower our security teams to be able to pass data along to each other to improve AI systems, right? So when we're talking about stakeholders in this discussion, regulatory discussion, we're opening up the playing field. It's not just the lawyers. It's not just the policy wonks. The engineers and the cybersecurity specialists need to have a huge stake in whatever discussion that we're having about AI, because they're the ones that are the ones actually making the technology. And I also think ethicists as well, folks who understand how this technology could be used against people, how it can be used against marginalized people. Those are kind of two groups of folks I think really need to be engaged in this regulatory conversation that are just kind of getting bypassed by state and federal legislatures right now.
If I could jump into, I agree. That's it. No, that was good. I think, and I don't know how they would be represented, but we're seeing with some of the litigation that's been lodged is how you group these as a constituency, but content creators are also a group that need to be consulted in some form or fashion. Money, money, money. Is that what you're?
No.
Okay. Well, I thought you were doing this. Well, so it's the folks who the writers, the artists, the music makers, all of those folks whose material has been ingested into these models. We use some closed source systems for some of the creatives that we generate. I don't know if you've seen any of our advertising. Hopefully you have. But we spend a lot on advertising. We spend a lot on marketing, and to be able to be comfortable with the imagery that we're creating, that we're generating, and so forth. We want to be working with content creators who have, in some form or fashion, given us permission that the works that we're using or deriving other works from have been licensed and so forth. So I think there is that constituency there. Some of that's going to be worked out in the courts, but you're going to get, kind of a mishmash depending on which circuit you're in, as we've seen with others. I would suspect that federal law will have to be, whether they can agree on it or not, but there will be something that would be needed to get some sort of sense of, how do content creators get compensated, or how is the licensing going to work? What permissions are going to be granted? Those kinds of things. What approvals will be made so that we have people who are continuing to be incented to create the content that is being used by these large language models.
Thank you. Yeah, I appreciate it.
Maybe we can take some audience questions.
Sure. We'll wait a few more minutes, then we'll head into some Q&A. If you want to moderate that, I appreciate it. Thanks. So I got to ask Chris, when the CrowdStrike outage occurred earlier this year where you and your Palo Alto colleagues doing high fives? You don't have to answer. All right, but I did hear you say at FBI headquarters about 3 months ago that you feel the most imminent threat to organizations is the risk of data leakage through AI-driven technologies. I'd love your commentary on that.
Yes, sir. Absolutely. So I think one of the hidden perks about working in cybersecurity is that you get yelled at a lot or chewed out. Most of the reason for that is you're blocking some kind of service or cloud-based application from a business unit leader. I'm sure most of you have been on the other side of those phone calls, probably with your IT staff. The reason why I bring that up is there's 60,000, I think the last time I checked, cloud-based applications. 2,000 of them are already utilizing generative AI. And the way that we make those conversations, or the way that we allow our IT staff to get our hands around those cloud-based applications where you're potentially leaking data, I think starts with policy. So work with a lot of clients. The AI, when I bring up something like an AI policy, is again kind of maybe a lot of the deer in the headlights look, or they don't really know where to start. Where I would recommend to start is establishing an AI policy committee, right? So we talked about it at a macro level, regulators, but internal to your organizations, there should also be essentially a governing body that's approving the use of AI within your organization. So including stakeholders from the executive team, your board of directors, your data scientists, your cybersecurity team, and your IT team. So you have technologists, you have business unit leaders, you have decision makers, all that are approving the use of AI. I think other things that you have to do within that policy are define terms for AI, right? A lot of business unit leaders are not fluent in that language. A lot of technologists are still learning it, right? But then more importantly, you have to define what are your guiding principles for utilizing AI? What's approved use? What is not approved use? What's high risk usage? And most importantly, how do you approve AI usage within your organization? So we go to clients a lot and we talk about on-premises software, right? That doesn't really change. The risks associated with software don't change because it moves to the cloud, right? We have to start thinking about cloud-based applications the same way that we do on-premises software. The last thing I would say there too is I think there's an emphasis for third-party governance, right? Your users might be utilizing these generative AI platforms without you even knowing, right? On a daily basis, they might be leaking data, they might be sending proprietary information, sensitive information. You have to understand what vendors that you're utilizing, right? Who you're sending data to, and then also start thinking of it from an even wider lens of just because an organization says that they use generative AI or says they don't use it right now doesn't mean they're going to in the future. Every organization is going to try and find ways to leverage the power of that data to improve their business, right? Grow their business. We have to start thinking about every vendor as potentially utilizing this technology in the future. And we have to have very tight controls of the data that we're sending to them.
Thanks, Chris. Actually, Ray, let's go back to you and we'll wrap it up here in a few minutes before doing some Q&A. Any landmark AI cases on the horizon other than New York Times that you think may reshape AI regulation down the road?
Well, that's where I was going to lead. So you just pulled it right out from under me, but that's okay. I do think, and just expanding on that point earlier, I think that those are going to be the landmark cases in terms of the creator suits, the Sarah Silvermans, the New York Times, the other folks who have complained that their original works were used and are arguably being infringed upon. Whether they are actually being infringed upon, I think is a really novel legal question, and we'll see how that goes. I think there are other areas of the law that are going to be tested here as well, though. I think that from the standpoint of data privacy, and that was touched upon earlier in terms of your photos and facial recognition, there's been a lot of concern about that, particularly by law enforcement, but it could be by others as well. Liability for AI generated content, who's at fault? How are we going to assign that? For us in the insurance industry, to what extent is bias and unfair discrimination being exacerbated by the use of AI? We all know that we all have our biases. We all have some of our predispositions. is that finding its way into the AI? And is the AI then learning from that and exposing it even more? We've seen some of that with some very famous fails, even in the previous generation. So everything before November 2022, when ChatGPT was unveiled, where you've seen in their hiring realm, I think it was Amazon that had put together a program by which they were screening people for tech jobs. And they were looking back at the prior 10 years. So this was maybe 2017, looking back at the prior 10 years and finding, well, there were mostly men in those jobs. So we'll look for men going forward. Yeah, that could be a problem. So I think when we think about where things can go wrong, where AI can go off the rails, it will be in the things that it learns and then expands upon. And it can be good and it can be bad. And that's where I think we're going to see, at some point, we're going to see some litigation around how AI has disaffected people, discriminated against people, created incredible biases against certain constituent groups and so forth. And that's what we're going to have to be worried about. I do think that there are obviously going to be data privacy things and so forth, but to me, that's probably the biggest thing. Second, depending on how you want to weigh it out, to I think the initial question with content creators, how are they going to be dealt with going forward, is using their content. When you think about the vast amount of content that's been created over hundreds of years, if their little article is used in training, is that an exploitation that's untenable legally? Some would argue yes, some would argue no. I think it's a really interesting question when you try to pull that together. So we're going to see going forward what direction that takes. But if you're a budding IP lawyer, I think there's going to be a lot of interesting things for you to be thinking about and be consulted about going forward.
No, absolutely. Thanks, Ray. So speaking of the good and the bad, let's end on some good stuff in terms of some good questions. We have some time for Q&A. Matab, if you'd like to handle that portion, and then we will.
Thank you. Hi, thank you all for being here. Nick, our hats are amazing, by the way. So you guys, especially I guess Nick, this is more so for you, Brenda and Jess. You talked a lot about like some ethical things when it comes as far as like using AI. So like for instance, one of my previous professors, she said like encouraged us to use AI, but if you use it in, you know, your paper or anything, you have to cite it. And I felt like that was a good approach. And then I have a different professor that's just like only grammatical. I personally have experience where I'll ask like ChatGTP, like, hey, is there a case that talks about this? And then they'll give me the case, and then I'll go to Westlaw, and that does not exist. So I personally am not going to be using it for anything else. But my question is, instead of, I guess, figuring out how our laws as is can be used to, I guess, navigate through the challenges of AI, does it make more sense instead to just introduce new AI specific laws where, yes, those other things that will apply to non-AI things, you still need to be hitting those, but specifically in addition to, you need to do this?
This is a fabulous question. Thank you for asking it. I'm curious what my co-panelists think as well. We learned a lot of lessons from regulating the internet specifically. One of the big lessons that we learned was from the DMCA. The DMCA is incredibly rigid. That's the Digital Millennium Copyright Act for online services. It's incredibly rigid today because the internet has changed so much. Technology is constantly evolving and innovating. And so it's my opinion that no, we shouldn't be regulating for the technology, especially because AI is moving so quickly. I think the risk that we have there is once we've codified something, the technology will have changed so much that again, we're going to be left with a very very rigid proposal that, one may not cover a lot of the gaps that come up with the new technology, new innovations, but also may hinder our innovation as well. I actually think the right approach is thinking about what Ray was talking about just previously, which is thinking about the impacts to people. And then do our existing laws, as currently written on the books, do they address those specific harms to people? And so like we think about deepfakes and non-consensual exploitative imagery. Do we need a federal publicity rights law because people in certain states who are being harmed by this technology or being harmed by deepfakes, they're left unprotected, whereas folks in other states are protected. So I think a harm-based focus with the idea that that technology can enable those harms is a better way to approach it than a technology-centric focus on regulation.
Yeah, I feel like I agree with that for the most part. The only place I would push back on is that maybe if we are going to create some new laws, maybe we do it in a broad enough way. I completely understand what you're saying. You don't want to create a box and then say, okay, and the only things that are on this paper are AI. And it's like, oh, well, what about this over here? Right. That's going to be a problem. But so like, I think one of the things that could be like beneficial in regulation is potentially, requiring a lot of transparency, making sure you can understand how you got this like where did this input come from? How did you get to this output? But so basically something that is very broad as opposed to something that you might say is like very specific for a specific situation.
So I know I've sounded like an AI obstructionist in terms of into the law. There is going to be a time, right, in your career where you will probably be required to use AI, right? You think about it, a lawyer couldn't exist today who uses the typewriter. Right. I mean, a lawyer couldn't exist today who couldn't e-file or use email and charge his clients for filing hard copies at a court system. Right. And so eventually the technology will be such that will be required. It'll almost be required under 1.1 to use it. And so although now is not the time that you have to implement AI in your practice, there will be. And I don't know when that is. And so, at some point, even I will have to do something and learn more about it. So, it's here to stay, and just make sure you do it the right way, and have a firm policy, make sure you communicate with your clients, make sure you know your AI platform, and kind of like you said at the beginning of your question, and I think this is a standard rule, verify or violate the rules, right? Verify or violate. And that's what I think you have to do.
I think one of the things that we see too is that with these new technological breakthroughs, it's still an extension of things that already existed. And I tend to agree with Jess in terms of the harm that can be the result of the use of some of these new tools. But the introduction of the internet was amazing, transformational. But it was kind of a new way of delivering some of the stuff that we were already delivering. Cloud computing, mobile technology, just, great new tools that we had at our disposal, but some of the same problems, that we've had before. I work also with our Snapshot program, which is usage-based insurance. And but an adjunct to that has been, if not autonomous vehicles, vehicles with significant amounts of automation associated with it. And people are like, well, that's new because now it may not be, your fault as a driver, because we typically have a tort-based system for, allocating fault. It may be because of the software. Well, we have laws about that. It's product liability. So so I think you raise a great question, and it's really just a matter of how we want to think about it. Is it something that is just a new way of delivering kind of the old thing, or is it, it's still kind of an extension of what it is that we're doing? in my world, in the insurance world, we've had a number of states that have adopted some new rules around AI, but others that have said, oh yeah, we can still ask you about this and question your practice and so forth, because it's still based on, are you pricing people appropriately? Are you underwriting appropriately? Are you treating people fairly when it comes to adjusting their claims? You know, it's still kind of those fundamental issues that we have to deal with. It's just a new way of maybe getting to some of those results. So really good question, though.
Within the realm of languages, what are like our high-level thoughts on AI's continual integration and improvement in being able to produce high-quality translations efficiently for potential and existing patents that are seeking global scope and protection, PCT applications, EP validations, unitary, direct route, and then you guys can comment on both the good and the bad of that, and then what are like currently the difficulties in AI translation that is keeping human translators feel like they have job security now and in the future?
Yeah, so I'm not sure how like AI translators are going to affect human translators in the future. I do know that right now, when you are prosecuting patents and stuff like that, usually it's relatively simple to get a machine translated or an AI translated patent. So like I was working on one earlier this week. The examiner cited a Chinese patent against my client, and I was able to just go to Google and type in the Chinese patent number, and Google itself gave me a translated version. The patent office has their own way of doing a machine translated version, and then there's other services that you can do it just for free. One of the problems with AI translation, though, is of course it's not going to be as specific, especially to like the very specific widget that you might be looking at. So if, for example, you're saying, you know, I want this very, you know, specifically insulated cup, and I'm using a very specific chemical to make that insulation, maybe you're getting some different translation depending on what service that you're using. Whereas if you use a human translator, they're going to understand, okay, here are all the nuances. So if you're doing litigation, so I've done both prosecution and litigation. When you're doing litigation, you're always going to pay for a human to translate whatever that reference is. If you find a good reference, you're going to look at it first through an AI perspective, just like as a threshold, and then you're going to ask for a human to come in and give you a more specific one. So I think their jobs are safe for now. But it definitely makes things easier, at least at that threshold perspective. I think it can be beneficial.
I thought you weren't doing anything with chemicals.
That's fair. It's a hypothetical.
Do we have time for maybe one more question?
One more here and one online.
Perfect.
Okay.
Thank you. So AI is really complicated, so I want to talk about a slightly different topic, biochemistry, significantly easier. Referencing back to something that was said in the last panel, you don't have to reduce all inventions to practice. The exception tends to be the harder sciences, the chemical and the biochemical. But recently, there's this fun little invention called AlphaFold, which uses AI to fold biochemicals, really big, complex biochemicals, which to me sounds like they're slowly moving to getting rid of the hard reduction to practice requirement. So to any panelist who wants to take on this Goliath, are we slowly approaching, asymptotically so, towards AI giving us full enablement of novel biochemicals? I hope. All right, that's all I have to say. Please.
I wish I understood more about biochemicals to give a better answer to this question. It sounds very interesting, but I'm not familiar at all with protein folding or anything like that. But I would argue that, I don't know. I think having seeing it proving that it can be done is different from actually showing that it has been done.
So thank you. I think that'll be enough for the questions in here, and then we'll switch to one more online. On the patent point, we have a few questions on the patent stuff, but we'll talk about that with the next panel as well, which includes some biochemical patent prosecutors. And so one last question before we wrap up was directed towards Christian, and that is with the potential for poisoning data sets as one potential way to fight against AI if you don't want an AI to be taking your work. Do you feel that that is harming somebody else's property when you are poisoning an AI system? And if so, should that itself be some sort of tort liability or something where people should be responsible for that?
That is a great question. I'm just going to put a full disclaimer out there that I do not have a law background at all. I guess from an ethical perspective, and I'll pass that to some of my colleagues. From an ethical perspective, I definitely would say, right, you're essentially, it's the same thing as hacking into a system, right? And modifying a database, right? You're modifying data to change the outcome away from what a business is intending to. I can talk to the technical perspective. There is kind of a light at the end of the tunnel there that we are starting to formulate security solutions for this. There are runtime security modules for LLMs now. So if you are looking to implement AI within your organization, that is a concern. There are security tools around that. I will pass it to my colleagues though for the other portion.
This is such a fun question. As a torts professor and as an internet law professor, and Christian, it's an opportunity for you and I to actually mind meld a little bit. But this is a really fascinating Computer Fraud and Abuse Act question as to is it unauthorized access to try to poison the? I think what's the appropriate terminology here? Poison.
Yeah, definitely. I would say unauthorized access. That's pretty much.
Yeah. So interesting, like trespass to chattels questions. I think it's going to turn on again. Unauthorized access. Harm is really big when we're talking about CFAA versus like some state penal related issues. So like, does it actually do quote unquote legal harm? Does it actually damage the system? Does it dispossess the system in some way? Does it, does changing the way that the results might come up, or if you're going against, like if you're evading guardrails in ChatGPT, changing the way that the outputs might be delivered, is that a question of harm? And again, is like prompt engineering, is that a question of unauthorized access? Point is, we have a lot of case law on CFAA related, but I don't think we've gotten there yet with this specific question with AI. And I think it's a fascinating one to keep an eye on.
Terrific. Chris, Nick, Brenna, Jess, Ray, thank you so much. We appreciate all of you being here in person and online. Give us 5 minutes to switch out and enjoy the rest of the conference. Take care.
So we have a great panel coming up next, focused on the changes to intellectual property law and the state of intellectual property law. We have folks who have decades of experience and have seen how the intellectual property practice has changed over those decades. So to start with, I would love folks to give a brief introduction, saying your name, where you practice, what you practice in, and how long you've been practicing. And for many of you, that's going to be a long time. Maybe I'll start from Patrick and go over this way. Go ahead, Patrick.
Sure. So Patrick Norton, I am a partner at Jones Day, and I've been practicing for 26 years now. My practice is focused on patent litigation primarily, some trademarks, licensing, disputes as well. I do a lot of work in the medical device area, med tech sector. And just a quick note to harken back to something at the earlier in the day that Carl might have mentioned. I'm the one who does not have a technical degree, but majored in football in college. So, but I only mention that just because I do not have a technical background. And I think a lot of people think that they need one to practice in IP or in patents. And you do to prosecute and do certain things, but I don't have one, and it hasn't really hindered me. I view it as my superpower because juries don't have technical backgrounds, and neither do judges. And sort of my rule of thumb is if I don't understand it, there's no way they will. So we need to make technology understandable for people who don't have chemistry degrees. And I find that it's been very helpful. I think it's good for everybody to keep in mind, and particularly in patent litigation.
I'm Christina Mosier. I'm a partner with Baker and Hostetler, and I litigate all of the intellectual properties. And I will second Patrick's statement. I have a BS in interpersonal communications. So the science of communication is a great help when you are litigating some complex technology or not so complex technology, because your role as a litigator is to be the mediator, be the translator of the technology to the judge, to the jury. And so I've been practicing 26 years as well. And I started off doing entertainment litigation and then obtained my LLM degree in intellectual property. And when I came back to the States, I started in Cleveland, and I've been with Baker and Hostetler since 2005.
Hi, everybody. My name is Kim Pinter. I'm a partner at Calfee Halter Griswold. I have been with Calfee now since 2011. I've been practicing for about 16 years total, which seems wild to say. So unlike, my friends here, I have a science background, chemistry background, biology, mostly kind of focusing now on material sciences. I been patent prosecution my whole career, doing some M&A and diligence type work as well, agreements, but mostly focusing on the prosecution side, opinion work, everything up until litigation. My practice has kind of transformed now to more of client counseling, portfolio management. So really kind of, working with the client the whole way through the process. Working with the teams they have internally is probably my favorite part. And really just making sure we're kind of walking through not only just filing the IP, but how to launch products and how to safely navigate the various, IP challenges they'll face potentially throughout the world. So it's kind of what I do day to day. Now we're John.
My name's John Sapola. I have been an IP lawyer for about 35 years, almost exactly this month, maybe a couple of months more than 35 years. But I started at Patrick's esteemed firm, Jones Day, and I thought so well of it that my son is now there, is also a patent litigator. But anyway, I am at Calfee Halter and Griswold. I spent about 30 of my years at Calfee Halter, give or take a couple. I was the head of the IP group for 20 years. I've done virtually everything there is to do in the IP world. There's some years of my practice I prosecuted a lot of patents. There's some years where all I did was litigate and take depositions and go to trial for months on end. So I've seen all ends of the spectrum, and done a lot of trademark work early on in my career, done a lot of copyright related things, but for the most part, I do patent litigation. I also agree with Christine and Patrick in that having a technical degree or a really high level technical degree to do IP litigation is not like required. I have an electronic technology degree and no PhD, but I can understand. Our job is to really being able to understand technology and learn it from the people that you hire as experts or you work with. And if you can learn it and learn it as good as they have, because ultimately that case is going to go away in a month, a year, maybe even 10 years from now. And then you got to learn some new technology. But that's the good part about our jobs is we get to learn new technologies all the time. So anyway.
Great. And I'll get into some of the questions that folks asked on other panels that might relate to you guys in a moment, focused on things like how AI and all of that might change things. But to start with, there are also a lot of proposed substantive changes and proposed changes to the law in intellectual property. What are some of those that you see coming out? What are some of the ones that you think are going to be the most significant to the field?
Yeah, so one of the proposals that's out there right now that is of interest to me that I am following, and it's in the comment stage, or the comment stages may have just closed,
is a new proposed PTO rule regarding terminal disclaimers. And it's an interesting one in that in a terminal disclaimer, you usually disclaim, in a related patent, the any term that extends beyond the original patent, but this proposal would require the applicant to agree that the patent that you filed the terminal disclaimer for will no longer be enforceable if any other patent in the chain to which it's tied by the terminal disclaimer is ruled invalid. And so it sounds like it might be a little, nuanced thing, but frequently we have continuation practice in this country. And so patent applicants will obtain a patent, and then file another continuation and another continuation. And you can keep that going for a while, and you can have a number of patents in the family. And sometimes, in my experience in litigation, the patents down the road don't often resemble, the claims that issue don't often resemble what was originally described as the invention. And it starts using different words, and that usually tends to be the patent that gets asserted in the patent litigation. But there's been a lot of commentary on this one. I think some of my panelists, possibly John, may not agree with me on it. But I think it's an interesting proposal because they're trying to get to a problem that we have with continuation practice. And whether this is the best way to do it or whether it'll be successful, I don't know. But it's an interesting one that I'm keeping an eye on.
Okay, I guess I'll go next. So I know that there is discussion, particularly since, with AI deepfakes and with the NCAA lifting prohibitions on name, image, and likeness licensing of a national right of publicity statute. I know that the International Trademark Association is working on several different drafts of a model name, image, and likeness statute that would be appropriate for, the countries across the globe. I don't know how long that will take. I think that's longer term, but I do think that it's necessary because the current right of publicity statutory scheme is state-based, and in some places simply common law-based, in some places both. So I think that there is some need for a cohesive set of rules to govern these right of publicity issues nationwide.
So on the patent prosecution side, there's a couple, in addition to the terminal disclaimers, which is almost kind of, in my opinion, kind of tied. There have been some, which for the practitioners out there, there's some proposed fee increases for 2025, particularly with continuation. So I don't know if this is something, it seems to be kind of related in the sense of maybe there's a real push to kind of change this continuation practice that's kind of ballooned in a lot of instances. There's, there is a, a lot of us have used this. You file, you want to keep cases open. You don't know where you have cases of litigation or it's being challenged in an IPR. You want to keep these cases open. You file continuations. They're proposing surcharges for those now. So if you file a continuation now after 5 years, there's going to be a surcharge, everything like $2,500. And then if it's after 8 years, it's like $3,500. It's just a surcharge. That's a big increase in fees. So which will certainly deter some folks from continuously filing and maybe having a different strategy going forward. But I think that those might be related in a sense of trying to really kind of change this practice and shift kind of the strategy that practitioners are taking and clients are taking towards these really large patent families. A couple other things that are changing. I'm going to get real dry for a moment. For those of you that do practice, I don't know if anyone saw, there's in prosecution, if you have kind of a final rejection, you've been able to take advantage of this practice called this pilot program, which is an after final consideration pilot program, where you could have file it, you get another shot to interview with the examiner, they do another search, as long as you narrow your claims, and a lot of times that leads to an allowance. They just discontinued that like this past week. they're not going to renew it. So that's going to be a big change for a lot of folks that use that. And you're going to have to decide if you're going to file an RCE and pay the fee. I do think this is also fee-based. I think that they were losing out on fees. So I'm sad to see it go. So that's something that is kind of a big change here for some of us. I don't practice a lot in design patent work, but there was a change in that as well this year that's notable for folks who do utilize design patents a lot. There was a case, the Federal Circuit over the summer, that changed the standard for obviousness. So it used to be fairly easy to get a design patent. The standard, as long as it wasn't identical, I mean, the standard for obviousness was very rigid. And that has now been kind of brought over to more of the utility patent space, so using the gram factors, and it is going to be a lot more difficult now to get a design patent. So something to kind of keep your eye on if that's a space that you practice in.
John?
Let's see. I mean, through the years of my practice, I mean, I've seen so many changes. I mean, when I started practicing, there was no federal circuit. I mean, there's so many changes that happen, and the pendulum always swings back and forth as to whether we want a strong patent system, we want to, have really strong patents, or do we want to have a weak patent system where anybody can compete? It's very easy to copy or design very closely to someone's innovation. This rule that Patrick's talking about is really, if you think about it, the Commissioner of the Patent Office reports to the President of the United States. It's really brought on by, I believe, the pharmaceutical lobbyists that are financing, and the president's very interested in reducing the cost of drugs. So as a result, he tells the patent commissioner, come up with some rules to change the patent system. It's too onerous. It's costing everyone a lot on these drugs. So they come up with this new rule that really sort of changes the way practice is completely done and violates, I think it's 35 USC section 282, which provides that every claim in a patent stands on its own for validity. Because what this rule says, basically, if you get an allowance by filing what's called a terminal disclaimer, which if you prosecute patents is something that's pretty run of the mill. I mean, you file terminal disclaimers because you get an objection that what you patented before you own. Okay, what you patented before in this continuation family is what you're getting now that's new is obvious in view of that old stuff, but we'll let you get it. But you have to terminally disclaim the end of your patent life to expire the same time the older patent does. And most patents expire within 20 days of filing of the application in that entire family. So these continuations that you get, they are always going to expire on that 20-year days of the first filing in that family anyway. So, what they did, what this proposed rule does is that if you file a terminal disclaimer, if any patent in that family has any of the claims are ever held invalid, then regardless of what the words of the claims are, all the patents in the family are invalid. So really, all the claims in a patent are not standing on their own anymore in violation of 35 USC section 282, and I may have that number wrong. If you invalidate one claim in the family, you invalidate the entire patent family, all the claims, because they probably all have terminal disclaimers. And that is a massive change and weakening of our patent system. And what the patent office didn't do is say, oh, we want this only to apply to pharmaceutical patents. No, they're applying to the entire patent system. So what it's really doing is gutting the patent system in the interest of having cheaper drugs. I mean, when you really boil it down, that's the way I see it, because I've seen this stuff for 35 years. There's always political things driving these changes, and this is a massive change in my view. Another change that's, we represent defendants and plaintiffs and people that have patents and people that are trying to get around patents, almost 50-50. I mean, any one of our clients, Kim and my clients, we don't represent one or the other always. So I'm interested in the pendulum staying in the middle. I don't really want it to go one way or the other, because if it goes, the patent system gets too weak. Hey, we're patent lawyers. And clients start saying, why should I ever get a patent? Why should I get to pay you guys to get me a patent if these patents are not worth anything because they're so weak? And I'm telling you, you get that question a lot. So I like it staying in the middle. I like little uncertainty on either side of the fence there. And I really think over the past 15, 20 years, we've really weakened the system, both in the remedies, the way you prosecute patents, IPRs, all those things. And, that question's coming up a lot. There is a movement, in Congress, they really don't focus on the patent system as much as they should. There's a couple congressmen that are really interested in it. And they always come up with bills. There's a bill afoot. One of the changes I saw when I started practicing patent law, if you found someone, you went to trial and you won a patent infringement case, it was an automatic injunction. You stopped the other side from practicing. That was automatic. Now it's not. There was, because of a change, I think it's the Supreme Court decision, might be Federal Circuit. Now you have to prove irreparable harm to get that injunction, just like you normally do in every other case. And they abolished that automatic injunction again to weaken the patent system. But there's a movement afoot to go back to almost nearly automatic injunctions, and there's some bills pending in Congress. But you really got to watch what's going on politically. It really influences our patent system.
I'm just going to pick up on that one. So that bill that John's referring to and Carl referred to it earlier this morning, I think it's called the Restore Patents Act or something along those lines. And what it would do is make it a rebuttable presumption. It's like one of the shortest bills in the history of Congress. I think it's a sentence long. And it would add the sentence that says it's a rebuttable presumption if there's a finding of infringement. But the interesting thing is, I don't know if John caught himself, but he said, yeah, they're going to make it, the Supreme Court changed the law and made it just like every other case, which is the 4-factor test for getting an injunction. So I don't know. I think that, so I have not been at this as long as John, but I've seen the pendulum swing a little bit. And when I started practicing that, it was nearly automatic to get an injunction if there was a finding of infringement. But I'm not really sure that was about strong patents or advancing justice. What it was leverage. It gives leverage because the issue comes apart when you have non-practicing entities. The fact of the matter is when you have two competitors suing one another, you're probably going to be able to make out a decent case for an injunction using the 4-factor test. But when you have one party that doesn't make anything and the other party does, it's hard to make out a case of having irreparable harm when all you're suing for really is money. And the problem when you have that rebuttable presumption or an automatic injunction is that, to me, runs the risk of giving too much leverage to one side. I mean, back in time, not to pick at a scab or bring up a bad memory to one of my partners and mentors who dragged me into the IP section at Jones Day, but there was this case called Research in Motion versus NTP. And, they made Research in Motion made BlackBerries. Some of you may not even know what a BlackBerry is, but the older folks here do. And so they had a patent infringement case. NTP didn't make anything. And they sued and they were awarded a reasonable royalty in the case. And I think the damages were on the order of $20 million. But the judge there was insistent on an injunction. And so Congress at that time was not allowed to use iPhones. They were all using BlackBerries because they were the only ones who had secure email. BlackBerries were truly a superior email delivery device. Much better than iPhone is for an email device, but their internet and web browsing capabilities weren't up to par. But you have a situation where you're staring down the barrel of an injunction. You've got, the Wall Street Journal and New York Times writing articles every day about, the government's going to stop because nobody's allowed to use their BlackBerries anymore if they get an injunction. And so you have a $20 million verdict and it winds up getting a $600 million settlement. Now BlackBerry is no more, and the people who bought the patents and pursue them for NTP, probably on a beach somewhere. But I don't know if that was really good for the economy or the system. Just my perspective on that. Speaking for no one else but myself.
Christina, you look like you have thoughts to add.
Well, I was just going to kind of use that as a launching pad for another observation, which is that the Supreme Court has spent past decade, I think, telling patent practitioners that patent law is not special. Going back to original statutory interpretation, things like intent, bringing intent back within the standards that are applicable to other causes of action. And then the eBay decision as well. I think that was part of this, I guess, decade or two of the Supreme Court telling the Federal Circuit and patent practitioners that you're not special.
Yeah, I think you have this dialogue that seems to be taking place between all the different branches of government here. You have the Federal Circuit and the Supreme Court often having opposing viewpoints. And then the Supreme Court ends up issuing decisions that may not be in alignment with the patent bar. And then you have Congress, who right now is very much, as John noted with the pendulum swinging, is very much on the pro-patentee side and trying to get more protections for patentees and especially solo inventors. So the ecosystem shifts over time, and you have so many different branches of government that have different perspectives sometimes and different desires as to what they want to do. This actually comes back a little bit to the terminal disclaimer question too, because for many of the students, you might not know what they were talking about when they were talking about continuations and terminal disclaimers. We heard a little bit of a tidbit on it, but the big policy concern is that there are people concerned about pharmaceutical companies in particular using a process called continuations, meaning that you're going to get another patent that has the same priority as a previous patent that you filed. And you're going to make a continuation application that's going to give you basically a backdated priority date, which gets you behind prior art and makes it less likely that you can be found invalid. And so this continuation practice is used a lot by companies that really value patents, and pharmaceuticals are one of the industries that place a great value on patent rights. And so they've been trying to use these processes that are available under existing law to maximize the use of their patents. So there's been some pushback there as a policy matter, I think, from Congress.
Yeah, I think, it's interesting because, John alluded to the pharmaceutical industry. We mentioned the pharmaceutical industry. This Restore Patents Act that I just mentioned, I'm pretty confident it actually has it's the rare bipartisan bill. It's got a sponsor who's I think Chris Coons is one of the sponsors, and I can't remember who the Republican senator who's the sponsor of it. But in patent law is and always has been a little bit of a odd creature, politically. And even amongst people who may align completely with one party or the other, their interests when it gets to patent law can sometimes diverge. And you'll hear frequently that, if you read in the press, there might be the pharmaceutical industry on one side of an argument and big tech and Silicon Valley on another side of an argument, because they don't have the same interests when it comes to patents. So in an already dysfunctional system, it makes it even harder to get anything done, I think, legislatively. So it'll be interesting to see whether the Restore Act passes or the terminal disclaimer rule goes through or not.
I'll change the topic a little bit. At the end of some of the previous sessions, we got a lot of questions about AI. And I was going to talk to you guys about how practice has changed. And AI is one of the ways in which practice is starting to change. But I wonder in the patent space in particular, you have, for example, AI tools that are being used to make inventions so much easier. And sometimes AI tools, in the case of, for example, protein folding, can be used to reduce an invention to practice entirely. And we have some policies from the patent office that are saying, look, we can't allow patenting when the AI is the one that's contributing the steps that traditionally constitute inventorship under the Patent Act. So do you have any thoughts as to how AI is going to change things in the intellectual property space, and what patent practitioners or IP practitioners should be doing to make sure that they can stay up to date and protect their clients in that space?
Since I'm the patent side of things here, prosecutor here. So I mean, I think that AI, we'll see. I mean, we've talked a lot with our clients about how to utilize it internally and how they're using it mostly to protect their, their information, because a lot of this also is a little bit, depending if they're using a closed system where they're using a sort of a generative AI internally versus like using it kind of more open and using it throughout kind of without any blocks on it. So if they're allowed, so it's like, how are you inputting your data? Where are you like, how are you releasing this into the world? Are you releasing it into the company? Are you releasing into the whole kind of world of AI? And are you disclosing your invention in that way? So I think there's a little bit something we're navigating through in that way. As far as inventing, I mean, I think that's something that I think is going to be, we're going to kind of see how that plays out. I mean, from a reduction to practice standpoint, I think that, I mean, what I see is, I mean, you can constructively reduce something to practice and you're, if you can prove that it could work. But what I see and what I do, I mean, I wouldn't get a lot of patents granted if I don't have a lot of comparative data. So, I mean, so much of the chemical space and the material science space is based on comparative, because it's also these incremental improvements or these slight changes that might really impact properties, or you have to show that. So if you can't show that, you're not going to get a lot of like really valuable claims in the US. You might not even get a patent if you're taking Europe, because Europe does require data to prove to like in your claims have to be commensurate in scope with the data. So that would be really challenging. You can't just put one process and a patent file in, think you're gonna get some claims. That's just not, unless it's a completely groundbreaking space. That would be very surprising to me. But so I think it's all still going to really, I mean, as far as my space and the technology that I see, you really have to be kind of doing trials and showing improvements and showing data to get valuable claims. But now, granted, this is going to be very different in different technology spaces. So TBD on those, but that's from my experience. It's really data heavy, and you wouldn't get very far without doing it.
I think the interesting question that we saw in the last panel was about protein folding and specifically. And, when I was in the biochemistry lab, I worked a little bit on trying to identify what genes to mutate in a system in order to modify the shape of the protein to make it fit better in another space. And this is a tool that AI is particularly good at. I used to have to go kind of tinker with it, plug it into a E. coli and then see if it worked. And that will not be necessary anymore with AI models that can run all of that just on the computer. And so I think there are some applications where that conception step can also be done by AI too. If you imagine, okay, you tell the AI, give me something that fits on this receptor better than anything we've seen before.
And I think there's a difference there between tell me something that works, that makes this work, versus prove that this works. Mm-hmm. So we use a lot of modeling tools, in applications. We use a lot of modeling data. I think that that's fine, but that's not AI that's not asking it to invent for you. It's asking you to prove that it works. So it's showing the method. It's not putting in the pieces. So I think there's a distinction there. And we'll see how that plays out. But I think modeling is fine. I think we use that all the time. I think using AI for that is fine. But I would draw the line at using AI then to pick the components of that and how to do it. I think that's where you're entering in the
You run into
AI
eligibility
capability.
challenges
Right,
under the
right.
current patent office approach to that. Let's turn over to how practice has changed in general in IP since you guys have been working in this space. Can you tell me about some of the ways that you've seen changes in your practice? Maybe John, go ahead.
Well, when we started practicing, when I started practicing, I was at Jones Day. There was no email at all. There was, what we did was, and it's a very formal practice, and it was a very formal practice up until about 10 years ago. What I've seen is just with the technology explosion. I mean, in fact, I've told a lot of younger people at our firm, and Kim may have heard me say this. Listen, I lived through the email revolution, the internet revolution, the phone revolution, which is one of the things I think the most significant changes in your practice is having that iPhone on your side constantly and being expected to respond to emails, texts, WeChats, everything you can imagine within, hours on the weekend. Whereas we used to send a nasty fax to the other side on Friday afternoon and go out to the bar and not come back until Monday to see whether they were going to respond, It's really changed and it's gotten harder, quite frankly. I will definitely say that. I'm not gonna lead the AI revolution in our firm. No way. Okay. But I mean, just to let you know, I mean, I went to a deposition in New York City with my mentor. His name was Chuck Lyon at Calfee. He was an old line litigator, patent litigator in Cleveland, very well known. And we come into this deposition. There's like 4 lawyers from Skadden or some big giant New York firm. They all have these giant phones on their hips, like clipped on their belts. And we look around, and we're like, we're never doing that. and I think Chuck knows how to use his phone better than me. But anyway, so those are the kinds of changes. And I mean, the immediacy to respond to things and the technology. And we used to have to send, like, we'd have a litigation in California, we'd have to FedEx, our brief the night before so we could get filed by the local counsel. Every firm in Cleveland had messengers. They'd run around serving briefs on every other firm. Now we don't have any messengers anymore. I mean, these are massive changes. I mean, people's jobs get eliminated. They do. We used to have, document handling. We would lose so many patent files. Everything was paper. And we used to have people we paid just to go around scanning the barcodes on these files so we could find them because they would get lost constantly in our office. Now, I mean, there's, everything's electronic, all filing's electronic, everything. So many, many changes.
I think so. From when I started to now, I mean, I think that a lot of the changes I've seen just is probably mostly not substantively in the law. I'm just talking about the patent practice generally, and I think it's not specific to IP law. For me, it's just kind of the accessibility of it all. I started, I had all the availability in the world. I could be in the office every day. I could, you had no other commitments. You're just in the office. I think one of the challenges that we've probably seen consistently is still, navigating through some challenging times of your life, like, when you're having children or you're doing all these taking care of elderly parents or something. The accessibility of it is amazing now. I mean, it's so much more flexible and accessible than it used to be. And I think that having young kids, it would be more challenging if I knew if it was such a, rigid and you had to like be in the, we're very much in the office. Like I'd like to be in the office, but if my kid's sick, I'm home and I can do all my meetings at home and I have amazing video conferencing abilities from my office at home, like that kind of thing, I think is one of the most important changes I've seen. This actually kind of was sparked during COVID. It was one of my favorite takeaways from COVID was just having the fact that we've like this awesome video conferencing capability that has made it a lot more manageable to kind of navigate and to to feel like you can do and be everywhere that you need to be.
So when I started, I was practicing in California, and there were times we were still, filing paper copies of everything. And there were moments where I had the opportunity to take a day trip up to San Francisco or Seattle simply to get that extra day to file a motion for summary judgment. And that obviously has gone by the wayside. And so now I find myself at 3 a.m. completing a filing on Pacific time in my office at home. So I think that there have been huge changes wrought by technology. Not just the BlackBerry, which I fondly remember receiving.
Well, one other thing I would just point out, and this is something that's been happening over time, but but it ties in with some of these other concepts that we're talking about, and that is just the absolute explosion of data and email. And so when I first started out on cases as a new associate, you would go do document collection on site frequently at the client, and you would go around and you would ask them if they had any files. You would mark them, tag them, pull them out, and send them off to a copy vendor. Now, it's not like that. And you get terabytes of data, and the only way to go through it is to search and do searches. The first case I had that went to trial, I personally put eyes on every single piece of paper that was produced in the case. And that's didn't make me unique. It was normal then. It's impossible now. And so that leads to other things like, how do you do the document review? Like for young people who might be in law school or new lawyers out there, when some of us were starting out, you would start off by doing document review and document production. And now some of that is farmed out to, contract reviewers or, somewhere offshore even sometimes, depending on what the client wants to do. But then you've got to find other ways to create value in terms of your knowledge of what are in your documents. And that to me has been one of the things I've struggled with is as you become more senior, less of what's in the documents that your own client produced or the other side produced, and you're more dependent on others or AI or Boolean searches through the database or whatever the case may be in terms of how you're getting the hot documents or the relevant documents in the case.
I will say there's nothing like having human eyes on a thing, though. I think one time I heard a story where there was an associate going through a bunch of emails, and they noticed that the emails between two people frequently contained a lot of emojis. And just that little thing is something that I might not pick up on, but the person said, the way they're using that, I think they're dating. And they were able to pick up that there was this this potential avenue to explore in depositions as something to attack them on. And it's not the kind of thing that necessarily AI or tech can always substitute for. But I see what you mean about, with the mass of email production, oftentimes you do need some junior associate who's had their eyes on every document, kind of briefing you about the issues and the facts of the production.
But in a lot of these cases, there's no way anybody could put their eyes on every document because everybody asks for the moon in document production. Mm-hmm. Email's really the root of this problem because, I've already professed my love of the BlackBerry, but people used to call people on the phone, and frequently people don't do that anymore. Or they'll send you an email to ask if you're available to have a phone call. And it just creates an enormous amount of documents that wind up getting scooped up in having to be reviewed.
Mhm. One other question I had was how, specifically in intellectual property, things have changed with regards to workload, use of associates, where associates fit in to the case, and has that changed over time?
One way that I think technology has really affected the relationship with younger associates is that it's really integrated teams from offices across the nation. And so, regularly I'm working with associates in Houston or Columbus or Los Angeles. And so it makes that process of collaboration and also building up the young associates so much different because you get a wider exposure and you can really kind of handpick your team from any office.
So I would agree with that about other offices. The thing I dislike about technology the most is the in the office. Not maybe having associates in the office as much as I remember it being when I was associate. I think it's really difficult to kind of on the cuff chat with people about a case or bring people in on something that maybe just came up and when then you have to like set up a time to Zoom them. I mean, it's just not the same. So I think that as much as I love the flexibility and what technology has done with allowing us to kind of work from wherever, it's not really appropriate to always work from wherever in your development, right? So I think that there's an automatic loss in translation sometimes, but the other offices, I think it's huge because that's actually been so nice. It makes me feel so much more connected to our other offices, but less connected to the folks in my office. So.
Yeah, you really have to balance this technology thing and when you're in the office and when you're not in the office. I think like Kim said, I mean, technology is sort of attacking you. You get all these messages all day long, all night long. I mean, IP is very international, so you're getting emails and texts from China and Germany and everywhere else. And people you work with, some people are night people. They're working all night. I'm a morning person. I wake up at 4 in the morning, 5 in the morning. I respond to their emails. They send me emails at midnight. I mean, it's pretty funny thing, but you really got to be in the office. If you're going to be an associate, we're an apprentice business still. You got to learn how to deal with people. You got to be in the office and seeing how we work, and it's the camaraderie that's involved, and you really do to be trained. The associates that don't come in and the ones that don't have a lot of work, normally they're the ones that don't come in very much because they're not viewed. I don't want to say intentionally as unreliable, but if someone's in here all the time, I know they're interested in our work. I know the person better. I'm going to give them it's just a natural human thing. A lot of this stuff's just common sense. But at the same time, you're going to get attacked by this technology. If you want to go on vacation, that really helps. You can go on vacation now and you can work 2 or 3 hours if you have to in the morning or whatever, and be accessible and still be involved. And, you can even argue things with courts. Or another thing about courts I've seen that judges are a lot more receptive. Almost some of them require a lot of things to be done remotely. And so depending upon what district you're in and things, you can be in the court and be virtually. One thing that I think that I've discovered going through this whole COVID thing before and after, brainstorming, like getting together and talking about ideas on how to tackle problems and come up with strategy for cases, much better in person than over the internet. No one can convince me otherwise. I just see it happen. It's just the way maybe the human interaction is. Being in person, much more important. I don't think that's unique to the law either, but anyway.
Yeah, I would just echo those sentiments, but one of the things I would make just to build on John's point is a lot of people during, COVID and remote work, they really like it. and, they'll make their sales pitch to keep it. But, we've been doing this 20 plus, 30 plus years. The people who are harmed the most by being remote all the time are the younger people, candidly, because they lose out on being in there in the office and the collaborative things that John's talking about. But just in general, like I mentioned earlier with document review might not be the thing you do anymore, but that's just an opportunity to do something else. And this, I would just, as a general advice, something I tell all young associates who work for me is find a way to make yourself invaluable. And that's on any case. And it might vary from case to case what that might be, but it requires, being a little proactive sometimes, because if there's a task that's set aside as go review 30 boxes of documents and somebody told you to do it, you know what your job is. But when the other side's document production comes in and it isn't something that can be reviewed by that, it's loaded up by the vendor and now it's off on Relativity or whatever platform you're using, it doesn't mean you can't go fishing around in there and see if you can't find some important documents, because we're going to have to look through it eventually in some form or fashion. So, take ownership of the case. One of the partners I worked for early on in my career said, I will give you as much to do as you show me you're capable of doing. And if that's your attitude going into it, whatever the task is, you'll do well.
That's great. I'd like to switch into another related topic, which is, do you think that the responsiveness to the needs of women and underrepresented groups and people taking care of elders or other ones with particular needs has improved, specifically in the IP space? I know I was mentioning at our at dinner yesterday that I was the first woman in my practice group in DC, in the IP practice group in DC, to have a baby, and they didn't really know what to do with that. And so I wonder if things have changed in that regard, and how well you think that IP groups in particular are responding to those other needs that people have for other parts of their lives.
I'll let you take that one.
Okay. From my perspective, in sort of the non-litigation space, I've been really lucky. I've had a really good experience. CalFE has a really great group of women. We have a very diverse group. I think it's just kind of been natural. We get a lot of great candidates and a lot of women. I think that we've just done, I don't know, it's been nice. We have I think from my perspective sometimes all my clients are women and my associates are women. I don't know. It's just, it's been really nice. I think that from a perspective of a mom, I felt very comfortable. I had mentors in our group that were young moms and navigating it themselves, helped me through it. I mean, John called me on my maternity leave and made me partner.